authorized to participate in the proceedings were duly informed of the list of participants having filed written statements and provided with a link to a web portal managed by the registry from where those documents could be downloaded. The list of participants in the oral proceedings and the schedule of those hearings were communicated to the states and international organizations taking part in them. The participants were also informed of certain practical arrangements relating to the organization of the oral proceedings. The schedule for the hearings was also transmitted to the member states of the United Nations, which were not taking part in the hearings, and subsequently posted on the court's website. This morning, the court will hear a 30-minute presentation by the United Nations. This will be followed by the first part of Palestine's oral statement. Palestine will complete its oral statement this afternoon and will be followed by Egypt and Malaysia. Palestine has been allocated a total of 3 hours of speaking time, Egypt 45 minutes, and all the other participants will speak for a maximum of 30 minutes each. Before inviting the first delegation to address the court, I would add that, in accordance with Article 106 of the Rules of Court, the court has decided to make the written statements submitted to it accessible to the public after the opening of the oral proceedings. The written statements of states not taking part in the oral proceedings will be made accessible to the public on the first day of the oral proceedings. The written statements of states and organizations taking part in the oral proceedings will be made accessible at the end of the day on which they present their oral statements. The written statements in question will be posted on the court's website. Let me also take this opportunity to explain the procedure that will be followed in the event of questions being put by members of the court to participants in these proceedings. Such questions will be asked at the close of the hearings on the afternoon of Friday, 2nd May 2025, after the last delegation has completed its presentation. The written text of such questions will be transmitted to the participants by the registrar. Written replies should be provided by Wednesday, 7 May 2025 at 6 p.m. No written comments on these replies are envisaged. I now give the floor to the United Nations, and I invite Ms. Elinor Hammarskjöld, Legal Counsel of the United Nations, to the podium. Madam, you have the floor.
Thank you, Mr. President. Mr. President, members of the Court, it's a great honour for me to appear in front of you on behalf of the Secretary-General of the United Nations in the context of this request for an advisory opinion. At the outset, I want to underline that the Secretary-General is making every effort to alleviate and bring to an end the ongoing and persistent human suffering of the population in Israel and the occupied Palestinian territory, including the hostages and their families, and all those affected by the ongoing armed conflict. There is an urgent need to return to a ceasefire and for the parties to respect their obligations under international law. The Secretary-General has consistently reiterated his strong and unequivocal condemnation of the abhorrent acts of terror by Hamas and other Palestinian armed groups on 7 October 2023. He has also repeatedly called for all the hostages to be released immediately and unconditionally. No humanitarian aid or commercial goods have been allowed into Gaza since the 2nd of March, which has devastating humanitarian consequences in the Gaza Strip. The Secretary-General continues to call for humanitarian aid to reach all people in need. As I stand before you, 295 United Nations personnel have died in Gaza since the 7th of October 2023. Mr. President, the request in General Assembly Resolution 79232 that the Court render an advisory opinion focuses on the obligations of the State of Israel. This statement will therefore do likewise. Before doing so, I want to reiterate that all parties to a conflict must comply with all their obligations under international law, including international humanitarian law and international human rights law at all times. In the context of the situation in Israel and the occupied Palestinian territory, Israel, the State of Palestine, and non-state actors, including Palestinian armed groups such as Hamas, have obligations under international law that must be observed. Monsieur le Président, Mesdames et Messieurs les juges, l'objectif de cet exposé oral est d'assister la Cour dans le cadre de la présente procédure consultative portant sur les obligations d'Israël en tant que puissance occupante et membre des Nations Unies. En ce qui concerne la présence et les activités des Nations Unies dans le territoire palestinien occupé et en lien avec celui-ci. Les Nations Unies ont un intérêt spécial et direct dans cette procédure. Des informations détaillées ont déjà été fournies dans l'exposé écrit sur la présence et les activités des 13 entités des Nations Unies qui se trouvent sur le territoire palestinien occupé. Je ne répéterai donc pas cette information aujourd'hui. Je me limiterai à rappeler que toutes ces entités sont des organes subsidiaires des Nations Unies au sens de la Charte ou font partie du secrétariat des Nations Unies. Je souligne à cet égard que le statut de ces entités est irréfutable. Ces entités sont engagées dans la fourniture sans entrave d'articles de première nécessité essentiels à la survie de la population civile palestinienne. Aussi, dans certains cas, ces entités sont engagées dans la fourniture de services de base et d'une aide humanitaire et d'une aide au développement dans l'intérêt de la population civile palestinienne et à l'appui du droit du peuple palestinien à l'autodétermination. Aujourd'hui, mes propos seront exposés de la manière suivante. En premier lieu, je me référerai aux obligations d'Israël en tant que puissance occupante. En second lieu, je me référerai aux obligations d'Israël en tant que membre des Nations Unies. Mr. President, members of the Court, I will now elaborate on the obligations of Israel as an occupying power. After making initial preliminary remarks, I will turn to three specific issues. First, the scope of relief schemes under the Fourth Geneva Convention. Second, the limitations on the authority of the occupying power to administer an occupied territory. And third, the protection of humanitarian, medical, and United Nations personnel in general. Israel has several obligations in relation to the presence and activities of the United Nations in the occupied Palestinian territory by virtue of its status as the occupying power. These obligations include the following obligations under international humanitarian law: the overarching obligation to administer the territory for the benefit of the local population, the obligation to agree to and facilitate relief schemes, the obligation to facilitate the proper working of all institutions devoted to the care and education of children, and the obligation to maintain the medical and hospital establishments and services, including those set up by United Nations entities. In the specific context of the current situation in the occupied Palestinian territory, these obligations entail allowing and facilitating all relevant United Nations entities to carry out their activities for the benefit of the local population. In addition to international humanitarian law obligations, international human rights law obligations are also applicable to the conduct of Israel with regard to the occupied Palestinian territory. This includes respecting the decisions of the representative of the Palestinian people to receive basic goods and services from the United Nations entities in order to fully enjoy their right to self-determination. Israel is bound to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Israel has the obligation to render assistance to such activities of the United Nations. Mr. President, members of the Court, against this background of an overarching framework, I would like now to move specifically address 3 points of international humanitarian law. First, I would like to address the scope of relief schemes under Article 59 of the Fourth Geneva Convention. I recall that under Article 59, the occupying power is required to agree to relief schemes and facilitate them if the whole or part of the population of an occupied territory is inadequately supplied. Article 59 refers to relief schemes in general. The plain terms of Article 59 do not limit relief schemes to objects that are urgently needed for the survival of the civilian population. Article 59, paragraph 2, specifically refers to foodstuffs, medical supplies, and clothing. These are examples of relief supplies and do not constitute an exhaustive list of objects that constitute relief schemes. The content of relief schemes depends on the needs of the population of an occupied territory. The legal obligation covers those needs that have to be addressed immediately. For example, when a large number of population is displaced due to military operations, relief schemes would comprise items that are essential to address their immediate needs, such as food, water, shelter, and hygiene facilities. The definition should also be understood to cover needs which may be more long-term, in particular in cases of prolonged occupation. For example, relief schemes to address long-term needs may include items that are essential for the construction and repair of certain infrastructures, including medical and sanitation facilities, and items and services to eradicate poverty. Therefore, the needs of the population in an occupied territory could evolve depending on the nature and duration of the occupation, and relief schemes need to be adapted to the evolving needs. The occupying power must agree to such relief schemes as adapted and facilitate them. Second, the authority of the occupying power to administer an occupied territory must be exercised in a manner that is consistent with international humanitarian law. Any measures taken by the occupying power to ensure its security must be exercised in a manner that would not deny impartial humanitarian organizations, such as the United Nations, the ability to carry out relief schemes, while part of the population of an occupied territory continues to be inadequately supplied. In instances where the occupying power has concerns with the impartiality of a humanitarian organization, the occupying power may not unilaterally declare that such humanitarian organization is not impartial and deny its relief schemes. Such concerns must be addressed in consultation with the humanitarian organization concerned. I will elaborate on this point later. Third, under international law, including international humanitarian law, humanitarian relief personnel, medical personnel, and United Nations personnel must be respected and protected. As such, attacks may not be directed against such personnel as long as they are entitled to the protection given to civilians under international humanitarian law. At every stage of the conduct of military operations, all feasible precautions must be taken to avoid, and in any event to minimize, incidental casualties to humanitarian, medical, and United Nations personnel. They must be treated humanely and must not be subjected to harassment or intimidation. They are also protected by international human rights law. As such, they must not be subjected to arbitrary arrest or detention. United Nations personnel, including those who carry out humanitarian and medical work for the United Nations, are also accorded particular status under the Charter of the United Nations and the Convention on the Privileges and Immunities of the United Nations, to which Israel is a party. Consistently with their status as United Nations officials or experts, United Nations personnel may not be attacked, arrested or detained, or subjected to any form of legal process in connection with their official functions. Privileges and immunities are granted to United Nations personnel in the interests of the organisation. Interference with their functions impedes the activities of the United Nations as an organisation. Mr. President, members of the Court, I will now move on to the second part of my statement, which concerns Israel's obligations as a member of the United Nations. I will start by recalling the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. I will then recall the general obligations arising from the Charter and the 1946 Convention on the Privileges and Immunities of the United Nations, which I shall refer to in my statement as the General Convention. I will then specifically discuss, first, the inviolability of United Nations premises, second, the general obligation of cooperation with the United Nations, and third, the issue of impartiality of certain United Nations entities. Mr. President, members of the Court, I will now turn to the first point, the unlawfulness of Israel's continued presence in the occupied Palestinian territory and the relevance of this to the present proceedings. Under international law, states, including members of the United Nations, are prohibited from acquiring territory by force. In the advisory opinion of 19 July 2024, this Court concluded that Israel's assertion of sovereignty over and its annexation of certain parts of the occupied Palestinian territory constitute a violation of the prohibition of the acquisition of territory by force. On this basis, the Court has authoritatively determined that Israel is not entitled to sovereignty over or to exercise sovereign powers in any part of the occupied Palestinian territory on account of its occupation. The enactment of the law to cease UNRWA operations and of the law to cease UNRWA operations in the territory of the State of Israel by the Knesset of Israel on 28 October 2024 appears to constitute an extension of sovereignty over or exercise sovereign powers in the occupied Palestinian territory, including East Jerusalem. The same can be stated regarding any measures taken on the basis of those laws and other applicable Israeli law in the occupied Palestinian territory, including East Jerusalem. They are, as such, inconsistent with Israel's obligation under international law. Insofar as the law to cease UNRWA operations in the territory of the State of Israel, among other effects, prevents UNRWA operations in East Jerusalem, which Israel considers to be part of the territory of the State of Israel, the enactment and implementation of this law is also inconsistent with the international legal status of East Jerusalem. I will now turn to certain general obligations under the Charter. The present proceedings are crucial because they will afford the opportunity to clarify certain fundamental elements of the legal framework applicable to the United Nations. The status of Israel as a member of the United Nations entails several legal obligations concerning the presence and activities of the United Nations in and in relation to the occupied Palestinian territory. These obligations are all essential for the organisation to properly function and perform the mandates it has been entrusted by its member states. The exclusively international character of these functions and mandates is enshrined in Article 100 of the Charter. When the basic elements of this legal framework are not observed, the very nature of the work of the organisation on behalf of its member states is in jeopardy. The basic elements of the legal framework of the United Nations include general principles of good faith and cooperation with the organisation, obligations concerning the safety and security of United Nations premises, property, assets and personnel, and more specifically, obligations concerning the privileges and immunities of the United Nations and its premises, property, assets and personnel. Regarding these, I wish to note that the Charter confers certain privileges and immunities to the organisation so that it may fulfil its purposes, as Article 105 of the Charter makes clear. Such privileges and immunities are applicable to all entities that are integral to the United Nations, including its subsidiary organs such as UNRWA, which was established by the General Assembly as its subsidiary organ. In the written statement of the Secretary-General, the obligations stemming from the Charter and from the General Convention were elaborated in detail. These principles are well set in law and practice. In this regard, I welcome the fact that a clear majority of Member States, having submitted written statements, appear to agree on the importance of the privileges and immunities of the organisation and its personnel. Today, I wish to underline, before turning to certain specific points, the importance for United Nations operations of the obligation to uphold the immunity from legal process of the United Nations and its personnel, irrespective of which United Nations entity they may be assigned to. Equally important is the obligation to facilitate the movement of supplies, goods and equipment of the United Nations and the freedom of movement of its personnel. Particularly since the end of January this year, United Nations operations on the ground, specifically for UNRWA, have faced increasingly difficult conditions. Following the enactment and implementation of the Knesset laws, the issuance of visas to UN personnel has been further denied or restricted, and actions have been taken against UNRWA personnel in connection with their duties for the organisation. There has been unauthorised entry into UNRWA schools, and orders for their closure have been issued, notwithstanding the ongoing mandate for UNRWA activities. In this regard, it is necessary to uphold the privileges and immunities of the United Nations and its personnel. As set out in documents contained in the dossier provided to the Court, violations of these obligations have occurred. Differences arising out of the interpretation or application of the General Convention may result in a situation in which a difference under the General Convention has arisen between the United Nations and Israel. Mr. President, members of the Court, I would like now to elaborate more specifically on 3 points. First, I wish to emphasise the absolute and mandatory obligation to respect the inviolability of United Nations premises, property and assets at all times, including during armed conflict, in accordance with international law. Article 2, Section 3 of the General Convention provides that the premises of the United Nations shall be inviolable. Also, that property and assets of the United Nations, wherever located and by whomsoever held, shall be immune from search, requisition, confiscation, expropriation, and any other form of interference, whether by executive, administrative, judicial, or legislative action. Consistently with this provision, inviolability entails that state agents may not enter or otherwise physically penetrate or physically interfere with the United Nations premises without the prior consent of the United Nations. It also entails a duty on the part of the state to take all appropriate measures to prevent the United Nations premises being entered or otherwise physically penetrated, damaged, or interfered with by other actors. State officials, including members of the armed forces and domestic law enforcement authorities, may not enter United Nations premises without authorization by the United Nations. Any other form of interference is also prohibited by Article 2, Section 3 of the General Convention. These obligations, therefore, also prohibit any state authorities, including a state's armed forces or security forces, from hitting, damaging, or attacking United Nations premises, property and assets. There are no stated qualifications to or limitations on inviolability in the General Convention and other relevant agreements. There is no reference to inviolability being merely functional in nature, as is in the case for certain other provisions in the General Convention. Nor is there any reference in the General Convention to situations of armed conflict, civil unrest, or other emergency situations as constituting possible limitations on such inviolability. The respect for the inviolability of United Nations premises, property and assets is an indispensable precondition for the organisation to be able to implement its mandated activities all over the world, including in the occupied Palestinian territory. Serious breaches of international law have been committed by parties to the ongoing conflict, but a breach by one party does not excuse breaches by other parties. I will now refer to the second point, the general principles that enshrine obligations of cooperation with the United Nations. It is from the preamble of the Charter that we derive the notion that Member States have committed to combining their efforts to accomplish the aims of the organisation. Among the principles set out in Article 2 of the Charter is that all members, in order to ensure to all of them the rights and benefits resulting from membership, shall fulfil in good faith the obligations assumed by them in accordance with the present Charter. Another of the principles is set out in Article 2, paragraph 5 of the Charter, which requires in its first part that all members shall give the United Nations every assistance in every action it takes in accordance with the present Charter. Consistently with the Court's interpretation of Article 2, paragraph 5 of the Charter in its advisory opinion concerning reparation for injuries suffered in the service of the United Nations, in the practice of the Secretariat, Article 2, paragraph 5 of the Charter has generally been interpreted as meaning that member states are required to provide every assistance to the United Nations entities to ensure the effective implementation of their mandates. In this context, it has been generally relied upon when calling upon states to comply with their obligations under Article 105 of the Charter and the General Convention. In the present case, the United Nations action consists of the activities carried out by a number of United Nations entities in the occupied Palestinian territory. Such activities are carried out consistent with resolutions of the Security Council and the General Assembly, and with mandates provided by various United Nations bodies, in a context in which this Court has authoritatively held that Israel is not entitled to sovereignty or to exercise sovereign powers. In these circumstances, Article 2, paragraph 5 of the Charter is directly relevant in the context of Israel's responsibilities vis-à-vis the presence and activities of the United Nations in and in relation to the occupied Palestinian territory, in accordance with international law, including other provisions of the Charter. Finally, my third point, referred to in certain written submissions, relates to allegations that have been raised as to the impartiality of certain United Nations entities. The United Nations considers very seriously any credible allegations against the organisation, including those involving its personnel or misuse of its premises. Any such concerns must be brought to the attention of the organisation so that the matter may be considered by the United Nations in accordance with its legal framework, including the privileges and immunities of the organisations and its personnel. The organisation has established a framework to address and investigate specific allegations of incidents brought to its attention, which is in line with the status, privileges and immunities of the UN. With regard to allegations against United Nations personnel, the regulatory frameworks of the United Nations require such allegation to be confirmed through an internal administrative investigation, which may include referring the allegations to the Office of Internal Oversight Services, OIOS, for investigation. The ability of the United Nations to further inquire into allegations depends on the full cooperation of member states, including the provision of relevant documents and materials, without which the organisation may not have sufficient basis to take further action in specific cases. Where concerns relate to broader issues, the organisation has taken further steps to review the matter. For example, following allegations that have been raised against UNRWA and its personnel, UNRWA and OIOS have taken steps to investigate those allegations in line with the organisation's regulatory framework and continue to do so. In response to Israel's concerns regarding the neutrality of UNRWA personnel more broadly, the Secretary-General appointed the former Foreign Minister of France, Catherine Colonna, to lead an independent review to assess whether UNRWA was doing everything within its power to ensure neutrality and respond to allegations of serious neutrality breaches when they are made. The Secretary-General and UNRWA have expressed their commitment to fully implementing the review's recommendations with the support of Member States. We note that such steps have been welcomed by the General Assembly and by a number of Member States in their written submissions for these proceedings. Monsieur le Président, Mesdames et Messieurs les juges, je conclus en rappelant qu'Israël continue à lancer des frappes dévastatrices sur Gaza, des frappes qui continuent d'emporter la vie de nombreux civils, y compris du personnel des Nations Unies. En outre, aucune aide humanitaire n'a été autorisée à rentrer dans la bande de Gaza depuis début mars. En conséquence, le secrétaire général a pris la décision difficile de réduire la présence de l'organisation dans la bande de Gaza, alors même que les besoins humanitaires augmentent massivement et que notre inquiétude par rapport à la protection des civils croît. L'Organisation des Nations Unies est déterminée à exercer ses mandats dans le territoire palestinien occupé, y compris Gaza, notamment en fournissant aux civils l'aide dont ils ont besoin afin d'assurer leur service. Pour que les entités des Nations Unies puissent exercer leurs fonctions, toutes les parties au conflit doivent pleinement respecter leurs obligations en vertu du droit international, y compris l'obligation de protéger l'inviolabilité absolue des locaux des Nations Unies et l'obligation de garantir le respect de l'indépendance et du statut du personnel des Nations Unies. À cet égard, le respect par Israël de ses obligations en vertu du droit international est indispensable pour l'exercice par les entités des Nations Unies de leur mandat dans le territoire palestinien occupé et en lien avec celui-ci. Un tel respect du droit international est tout aussi indispensable pour la protection des civils et pour que les collègues des Nations Unies continuent à travailler pour sauver la vie des civils sans faire face à des risques intolérables. Le respect du droit international par toutes les parties prenantes demeure la seule option possible pour une paix durable, ainsi que pour la sécurité et la justice des Israéliens et des Palestiniens. Monsieur le Président, Mesdames et Messieurs les juges, je vous remercie pour votre attention.
I thank Ms. Eleanor Hamsholt. I now invite the next participating delegation, Palestine, to address the court. And I call His Excellency Ambassador Amal Hijazi to the podium. You have the floor, Excellency.
Mr. President, members of the court, it's an honor for me to present Palestine today and its proud people in these proceedings at a time of existential crisis for the Palestinian people and for the rule of international law. On behalf of Palestine's delegation, I wish to congratulate you, Mr. President, on your election as President of the Court and to wish you success in your tenure. Allow me also to express our gratitude to the courts holding these hearings on an expedited basis. As I address you today, the Palestinian people are being starved, bombed, and forcibly displaced by Israel, their unlawful occupier. Israel has not allowed food, water, medicine, and medical supplies or fuel into Gaza for the past 2 months, a policy supported by the highest court in Israel, which rejected petitions to allow aid into Gaza on several occasions. This man-made catastrophe of unprecedented proportions targets life itself. Death looms large, including by starvation, which has already claimed the lives of 59 Palestinian children. The UN Secretary General has described Gaza as a killing field, where civilians are in an endless death loop. Mr. President, we are here today because the General Assembly asked the Court to determine the legal obligations of Israel in relation to the provision of urgently needed humanitarian assistance by the United Nations, other international organizations, and third states, and in relation to the exercise of the right of Palestinian people to self-determination. This request was provoked by the international community's outrage at Israel's methodical targeting, banning, and obstructing of said parties, including its legislation banning the United Nations Relief and Works Agency of Palestine Refugees, UNRWA, from fulfilling its UN mandate in the occupied Palestinian territory, including East Jerusalem. There can be no doubt about the Court's jurisdiction in these proceedings. The question raised by the General Assembly is plainly a legal one. It specifically asks the Court to advise on Israel's legal obligations under international law and other rules of international law. Nor is there any reason, let alone a compelling one, for the Court to decline to answer it, as the Court has already determined in 2 prior advisory opinions, the question of Palestine is fundamental to the United Nations and its mandate in this case. This request was provoked by the international communities. During this presentation, the State of Palestine will present evidence on the devastating immediate, intermediate and long-term consequences of this unlawful Israeli policy on Palestine and its people, on every aspect of their fundamental rights and continued existence. The State of Palestine will also present the Court how Israel's prohibited conduct extends to the occupied West Bank, including East Jerusalem, because the target of these actions, by admission of top Israeli leaders, is the permanent annexation of the Palestinian territory and the ethnic cleansing of Palestinians. It is a self-incriminating admission that debunks the security sham they used to justify their genocide, as we will also demonstrate in our presentation. Mr. President, members of the Court, before I go any further, allow me to first address the context in which these deliberations are happening. This legal and moral crisis is not 18 months old. Israel has been systematically dispossessing, uprooting, slaughtering and imprisoning Palestinians in absolute flagrant disregard for international law and the inalienable rights of the Palestinian people for 8 years now. It has done so with the intent to destroy our people and to thwart the realization of self-determination in their homeland. To implement this policy, Israel has waged a relentless campaign of erasure against Palestinian people, their demography, their material presence, their national identity, their history and heritage, and their very humanity. This campaign of erasure was a central hallmark of the Nakba that started in 1947, and whose darkest chapter yet, unfolding before our eyes and yours. On 3 separate occasions in the past years, the Court issued provisional measures ordering Israel, among other things, to ensure and facilitate the unimpeded flow of humanitarian assistance into Gaza. Israel did not comply. On 19 July 2024, this Court also ruled that Israel's presence in and control over the occupied Palestinian territory is unlawful and must come to an end. The Court also ruled that despite the illegality of occupation regime, Israel was still bound by its obligations under international law as an occupying power. These obligations include ensuring the welfare of the protected civilians. Israel defied this ruling and the rule of law, brazenly declaring instead its official policy of annexing the occupied Palestinian territory, forcibly displacing Palestinian people, weaponizing food and humanitarian aid, and negating refugee issue and their rights, including by banning UNRWA. On 21st of November 2024, the ICC issued arrest warrants for the Prime Minister of Israel and now his former Minister of War, in part because they intentionally deprived civilian population in Gaza of food, water, medicine, and other essentials. To summarize, Israel is an unlawful occupying power, standing trial for genocide. Its Prime Minister is wanted by the ICC. It's attempting to destroy Palestinian people and erase Palestine, including by barring and obstructing humanitarian organizations, thus also violating its obligations under the UN Charter and other instruments of international law. That is the context of the question before you. Mr. President, members of the Court, UNICEF says Israel's onslaught has killed and injured 100 Palestinian children in Gaza every day since 18 March 2025. This is in addition to the more than 15,000 children Israel has killed since the onset of genocide, and the thousands who are still missing under tons of piling rubble of what was once their schools and their homes. Israel's genocidal campaign has turned Gaza into the home of the largest cohort of child amputees per capita in the world. Their limbs are amputated without proper medicine or care, sometimes without so much as a painkiller. Many don't survive, like baby Sham Mharib, whose arm was amputated following a strike on her home 18 days ago. Israel's genocidal campaign has also targeted UN and other humanitarian workers and organizations in Gaza, killing over 408 UN workers, among them almost 300 UNRWA staff. They have also killed 27 Palestinian Red Crescent Society paramedics in Gaza and 113 civil defense first responders. These killings are deliberate, not accidental. This was proven repeatedly, including in January 2024, when Israeli soldiers killed 6-year-old Hind Rajab and her relatives, then murdered the Palestine Red Crescent paramedic who received permission to rescue Hind while she was still alive. It was proven once more last March when Israeli soldiers ambushed and killed 14 paramedics and humanitarian heroes. The soldiers then buried the bodies in a shallow mass grave alongside with their crushed ambulances and emergencies in an attempt to hide their crime, while top Israeli officials lied to the world about the murders. This is the jarring equation prompting our appeals to the court and these proceedings. Israel is starving, killing, and displacing Palestinians, while also targeting and blocking humanitarian organizations trying to save their lives. These grave crimes aim to hasten the forcible transfer and destruction of Palestinian people in the immediate term. They will also ensure that our children will suffer irreparable damage and harm, placing an entire generation at grave risk. Already experts have concluded that life expectancy in Gaza has been slashed in half since the onset of the genocide. Mr. President, members of the court, this targeting of life in the Gaza Strip has been ongoing for years and in grave violation of Israel's legal obligation as an occupying power and as a member of the UN. Israel began engineering food deprivation in Gaza 19 years ago, making the majority of civilian population dependent on food aid to survive. A senior Israeli official then said, and I quote, "The idea is to put the Palestinians on diet, but not to make them die of hunger." End quote. Since October 2023, the blockade has progressively turned into a total siege. The Office of the High Commissioner of Human Rights said, "This siege is creating conditions that were incompatible with sustaining life or the continued existence of Palestinians in Gaza." These are the facts. Starvation is here. Humanitarian aid is being used as a weapon of war. All UN-supported bakeries in Gaza have been forced to shut their doors. 9 of every 10 Palestinians have no access to safe drinking water. Storage facilities of the UN and other international agencies are empty. More than 12,500 wounded Palestinians, including thousands of children, now require medical evacuation to have a chance at life. That is in addition to thousands of cancer and other patients dying slowly, dying in agony, and hundreds of thousands of children who live whose lives are in danger because Israel is denying entry of vaccines. Meanwhile, Israel continues to repeatedly, forcibly displace and starve the Palestinian population in Gaza. This UN-produced map illustrates how Israel has squeezed the population into a third of the Gaza Strip that it continues also to bomb. UNICEF, for example, has been forced to shut down 21 malnutrition clinics because of these repeated forced displacement orders. Israel has also waged a war on hospitals in Gaza, bombing them, laying siege to them, burning them, or leveling them to the ground. Israel has bombed and attacked all 36 hospitals in Gaza. The last hospital to be bombed was Gaza's Al-Ahli Baptist Hospital, an institution that has offered health to Palestinians since 1882. This hospital survived 2 world wars and many wars after, but Israel decommissioned it twice in the past 18 months. Israeli occupation forces have killed over 1,400 doctors, nurses, and other health workers. Some, like renowned surgeons Adnan al-Bursh and Iyad al-Rantisi, who were forcibly disappeared and tortured to death. Others, like director of Al-Awda Hospital, Dr. Ahmad Mhanna, was forcibly disappeared for over a year now, while director of Kamal Idwan Hospital, Hussam Abu Safiyi, continues to be unlawfully detained. Only a handful of hospitals continue to bravely function, thanks to the heroic Palestinian doctors who remain and the brave international doctors volunteering to assist them despite the dangers and severe Israeli restrictions. To understand what this means in real bone-chilling terms, I ask you here this brief testimony of Dr. Muhammad Mustafa, an Australian doctor who was volunteering in Gaza last March.
We've worked throughout the entire night. We haven't stopped. The bombing has been non-stop. We've run out of ketamine, we've run out of propofol, we've run out of all painkillers. We can't sedate anyone, we can't give them any analgesia. When we intubate people, they wake up and they're choking because we have no sedation. There are 7 girls getting their legs amputated, no anesthesia. The bombing is still going on, the room is still shaking. I haven't slept. We went to bed at about 1 o'clock and at 1:30 the bombing started. It's about 10 a.m. now. I've just gone back to my room. I'm lightheaded, I'm dizzy, and I mean, it was just mostly women and children, burnt head to toe, limbs missing, heads missing. You know, there's a video I put up on my story of me doing a chest drain. The gentleman that did the chest drain and he died on the way to the CT scan. There's another video of 3 girls laying on a bed. That's his 3 girls who are now orphaned. Their mother didn't even make it into the hospital. She was killed along with their other sister. I don't know what to tell you. I was here in June, nothing to this intensity. This is unbelievable, and the bombing is still going on. The rooms are still shaking. The screams are everywhere. It's insane.
Mr. President, members of the court, the carnage and destruction extends to the West Bank, including East Jerusalem. There, Israel's killing of Palestinian civilians, including children, was record-breaking for 3 years in a row before 2023. Since the beginning of the year, Israel launched a military assault in the West Bank, unprecedented since 1967. Israeli occupation have demolished, razed, and burned the refugee camps in Jenin and Tulkarem, forcibly displacing more than 40,000 Palestinians. And Israel has announced that the displaced will not be allowed to return. The World Food Programme reports a near 100% increase in Palestinians in need of food aid in the West Bank. Impeding the presence and activities of the UN and international organizations must be viewed in the context of erasure and forced displacement. Mr. President, members of the Court, before I stand before you today on behalf of the persecuted people fighting to survive, to live freely in our land. This is our inalienable and most fundamental right. It is not anyone to give or withhold, as this Court has repeatedly affirmed. That's really the heart of why Palestine and over 40 other states are addressing the Court today. It is not about the number of aid trucks Israel is or is not allowing into the occupied Palestinian territory, especially Gaza. It is not about Israel destroying it is about Israel destroying the fundamentals of life in Palestine while it blocks UN and other humanitarians from providing life-saving aid to the population. It is about Israel unraveling fundamental principles of international law, including their obligations under the UN Charter. It is about Israel turning Palestine, in particularly Gaza, into a mass grave for Palestinians and those coming to their aid. Before I conclude, Mr. President, allow me to describe the remainder of Palestine's presentation today. First, Mr. Paul Reichler will present Israel's legal obligations under international law and international humanitarian law. Next, Ms. Blinne Negroli will discuss Israel's violation of its legal obligations as a member of the United Nations. Then Professor R.D. Msis will address legal obligations specifically in relation to UNRWA. He will be followed by Professor Alain Pillay, who will discuss the legal consequences of Israel's violations of its obligations with respect to the provision of humanitarian aid to the Palestinian civilian population and the exercise of their right to self-determination. Finally, Ambassador Riyad Mansour will present the State of Palestine's closing remarks. I thank you for your kind attention and ask that you call Mr. Reichler to the podium.
I thank Ambassador Hijazi. I now give the floor to Mr. Paul Reichler. Sir, you have the floor.
Mr. President, members of the Court, it is, as always, an honor for me to appear before you, and it is a privilege to speak on behalf of the State of Palestine. And on behalf of all of my fellow counsel here as part of the delegation, we are pleased to echo the congratulations that were conveyed to you by our agent on your election as president. I will address Israel's legal obligations under international humanitarian law concerning the provision of humanitarian assistance to the Palestinian civilian population, and then Israel's legal obligations under the rules of international law set out in the Court's advisory opinion of 19 July 2024. I will conclude with some observations on Israel's legal obligations under overlapping rules of international humanitarian law and international criminal law. I begin with an update on the situation on the ground. On 1 March 2025, Israel announced that it would unilaterally end the 6-week ceasefire that had prevailed since mid-January, and that it would resume aerial bombardment and other armed attacks against Gaza. On the following day, 2 March, the office of the Prime Minister made this announcement. Prime Minister Benjamin Netanyahu has decided that as of this morning, the entry of all goods and supplies to the Gaza Strip will be halted. The Prime Minister's decision immediately cut off all humanitarian assistance to the Palestinian civilian population in Gaza. This was underscored by the head of Israel's civil administration for the occupied territory and Minister of Finance, Bezalel Smotrich, in another post on the same day. The decision we made last night to completely halt humanitarian aid to Gaza until Hamas is destroyed or completely surrenders and all our hostages are returned is an important step in the right direction, the threshold of the gates of hell. Now we need to open those gates as quickly and lethally as possible on the cruel enemy until absolute victory. Israel's Minister of Defense, Israel Katz, made clear that the cruel enemy was not just Hamas, but the entire civilian population of Gaza. He addressed this message specifically to them. Citizens of Gaza, this is your last warning. The Air Force attack against Hamas terrorists was only the first step. The rest will be significantly worse, and you will pay the price. Unless all the Israeli hostages are released and Hamas is expelled from Gaza, Israel will act with forces never before seen. The alternative is utter destruction and devastation. In keeping with these official Israeli statements, all humanitarian assistance intended for the civilian population of Gaza has been blocked by Israel since 2 March. No food, no water, no medicine, no fuel, no anything. For 57 days and still counting, Israel has prevented all goods and services of any kind from entering Gaza. On 9 March, Israel's energy minister, Eli Cohen, posted a picture of himself on the social media platform X, signing an order to cut off electricity to Gaza. The message accompanying the photo read, "I have now signed an order to cut off electricity to the Gaza Strip immediately. Enough with the talk. It's time for action." The impact of this action was to shut down the lone desalination plant in Gaza, depriving more than 600,000 Palestinians of their only access to water. Overall, the consequences for the Palestinian civilian population, especially the deprivation of urgently needed humanitarian assistance, have been, as promised by Defense Minister Katz, utter destruction and devastation. According to the United Nations Undersecretary General for Humanitarian Affairs, who briefed the Security Council on 18 March, today I am distressed to report that in addition to the intense airstrikes that have resumed, since 2 March, Israeli authorities have cut off the entry of all life-saving supplies, food, medicines, fuel, cooking gas, for 2.1 million people. This total blockade of life-saving aid and basic commodities and commercial goods will have a disastrous impact on the people of Gaza, who remain dependent on a steady flow of assistance into the Strip. Blocking food, water, and medicine for people who need them is unconscionable. It also goes against international humanitarian law and the provisional orders of the International Court of Justice. Mr. President, members of the Court, the Undersecretary General is plainly right. The facts on which his statement is based are not in dispute. As you have seen, they're admitted, proudly and loudly proclaimed by Israel's most senior government officials. Nor can there be any dispute about the applicable law. In its July 2024 advisory opinion, the Court explained that international humanitarian law governs Israel's conduct in the OPT for as long as its occupation continues. Israel must thus comply with its obligations under the Fourth Geneva Convention, of which it is a state party, and Additional Protocol 1, the relevant articles of which are part of customary international law. The indisputable evidence shows that Israel has flagrantly violated these obligations. They include, first, the obligation under Article 55 of the Fourth Geneva Convention to ensure, to the fullest extent of the means available, provision of, quote, the food and medical supplies of the population. Under this article, Israel has an affirmative duty to, quote, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate, which is undeniably the case throughout the Gaza Strip. Article 69 of Additional Protocol 1 further requires Israel to ensure the provision of, quote, clothing, bedding, means of shelter, and other supplies essential to the survival of the civilian population of the occupied territory. Second, Israel has the obligation under Article 56 of the Convention to ensure and maintain, to the fullest extent of the means available to it, quote, the medical and hospital establishments and services, public health and hygiene in the occupied territory. Article 56 further provides, quote, medical personnel of all categories shall be allowed to carry out their duties. Israel has been blatantly violating these obligations, and not only since 2 March, it has been violating them for many years, most egregiously since October 2023. On 9 October 2023, Israel announced a complete siege of the Gaza Strip, cutting off essential resources and the movement of goods, including food, water, medicines, fuel, and electricity. All crossing points between Israel and the Gaza Strip were sealed. Israel's defense minister at the time, Yoav Gallant, described his government's strategy in these terms, quote, a complete siege, no electricity, no water, no food, no fuel. The United Nations Independent International Commission of Inquiry found that this was precisely what Israel did. Quote, throughout the siege on Gaza, Israel has weaponized the withholding of life-sustaining necessities, specifically by cutting off supplies of water, food, electricity, fuel, and other essential supplies, including humanitarian assistance. On 6 December 2023, the Secretary General reported to the Security Council, we are facing a severe risk of collapse of the humanitarian system. The situation is fast deteriorating into a catastrophe with potentially irreversible implications for Palestinians as a whole and for peace and security in the region. In response, the Security Council adopted Resolution 2720 on 22 December 2023, which recognized that the civilian population in the Gaza Strip must have access to sufficient quantities of assistance that they need, including enough food, water, sanitation, electricity, telecommunications, and medical services essential for their survival, and that the provision of humanitarian supplies in the Gaza Strip needs to be sufficient to alleviate the massive humanitarian needs of the Palestinian civilian population throughout the Gaza Strip. And the resolution reaffirmed the obligations of the parties to the conflict under international humanitarian law regarding the provision of humanitarian assistance. And it demanded that they allow, facilitate, and enable the immediate, safe, and unhindered delivery of humanitarian assistance at scale directly to the Palestinian civilian population throughout the Gaza Strip. Israel ignored the Security Council's demand, just as it disregarded subsequent Security Council resolutions 2728 and 2735, adopted in 2024, and 5 General Assembly emergency special session resolutions, which called on it again to allow and facilitate urgently needed humanitarian assistance at scale to the Palestinian civilian population in Gaza. In fact, Israel did the opposite of what was demanded to it. It continued to impede the provision of humanitarian goods and services indispensable to the survival of the Palestinian people, and it restricted humanitarian access by United Nations agencies, other states, and international humanitarian organizations. The court needs no reminding that Israel also disregarded its orders on provisional measures in the case brought by South Africa, which were issued on 26 January, 28 March, and 24 May 2024. Israel was required by the March order to take all necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene and sanitation requirements, as well as medical supplies and medical care to Palestinians throughout Gaza, including by increasing the capacity and number of land crossing points and maintaining them open for as long as necessary. Israel has ignored these obligations and refused to comply. By May 2024, the court recognized that, quote, the humanitarian situation is now to be characterized as disastrous, as indeed it was. And the situation grew even worse thereafter. On 28 October 2024, the Commissioner General of UNRWA made this report to the General Assembly. The situation in Gaza is beyond the diplomatic vocabulary of the General Assembly. After more than a year of the most intense bombardment of a civilian population since World War II, and the restriction of humanitarian aid far below minimum needs, the lives of Palestinians are shattered. The surviving population lives in the greatest indignity. In the north, the population is trapped, awaiting death by airstrikes or starvation. On 2 December 2024, the Secretary General reported to the Cairo Ministerial Conference, nothing justifies the collective punishment of the Palestinian people. Collective punishment is, of course, prohibited by Article 33 of the Fourth Geneva Convention. Secretary General continued, yet conditions for Palestinians in Gaza are appalling and apocalyptic. Malnutrition is rampant. Famine is imminent. Meanwhile, the health system has collapsed. What we are seeing may well amount to the gravest international crimes. In the face of the gigantic needs, humanitarian aid is outrageously being blocked. This flies in the face of the clear requirements under international humanitarian law to respect and to protect civilians and to ensure their essential needs are met. It defies numerous General Assembly and Security Council resolutions demanding a ceasefire and unhindered humanitarian access. And it ignores the International Court of Justice, which issued binding provisional orders that must be complied with. As appalling and apocalyptic as the situation was in December, it is even worse today. The Secretary General recognized this in a statement on 8 April. More than an entire month has passed without a drop of aid into Gaza. No food, no fuel, no medicine, no commercial supplies. As aid has dried up, the floodgates of horror have reopened. Gaza is a killing field, and civilians are in an endless death loop. The current path is a dead end, totally intolerable in the eyes of international law and history. And the risk of the occupied West Bank transforming into another Gaza makes it even worse. Mr. President, in these circumstances, there can be no doubt that Israel is violating its obligations under international humanitarian law, including its obligations under the Fourth Geneva Convention and customary international law, as reflected in Additional Protocol 1. In its written statement, Israel argues that its defense and security concerns justify its refusal to allow humanitarian assistance to the Palestinian civilian population, no matter how urgently this assistance is needed. This posture is as unlawful as it is inhumane. Under Article 59 of the Fourth Geneva Convention, as pointed out by the distinguished Undersecretary General for Legal Affairs earlier this morning, quote, if the whole or part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. The ICRC commentary on Article 59 explains, the obligation on the occupying power to accept such relief is unconditional. In all cases where occupied territory is inadequately supplied, the occupying power is bound to accept relief supplies destined for the population. The Convention not only lays down that the occupying power must agree to relief schemes on behalf of the population, but insists that it must facilitate them by all the means at its disposal. The occupation authorities must therefore cooperate wholeheartedly in the rapid and scrupulous execution of these schemes. Article 59 itself further provides, quote, all contracting parties shall permit the free passage of these consignments and shall guarantee their protection. The ICRC commentary explains that these obligations apply to any state that is enforcing a blockade, and it specifies that the consignments, quote, cannot, under any circumstances, be declared war contraband or be seized as such by those enforcing the blockade. Mr. President, the question posed by the General Assembly calls for the Court to issue an opinion on Israel's legal obligations, and I quote, to ensure and facilitate the unhindered provision of urgently needed supplies essential to the supply of the Palestinian civilian population, as well as of basic services and humanitarian and development assistance. This question assumes that the relief consignments are humanitarian in nature. As such, international humanitarian law does not permit Israel to deprive the Palestinian civilian population of such assistance for any reason, including what it claims are its defense or security requirements. This is the conclusion reached by the ICRC itself. In relation to the current situation in Gaza, the ICRC has stated, the suspension of assistance now, including the cessation of power to the only water desalinization facility in Gaza, risks plunging Gaza further into an acute humanitarian emergency. Under international humanitarian law, Israel shall ensure that the basic needs of civilians under its control are met. The rapid and unimpeded passage of humanitarian assistance must also be allowed and facilitated. I now turn to Israel's legal obligations under the rules of international law applied by the Court in its 2024 advisory opinion. I refer specifically to the Court's determinations that Israel has no sovereignty and may not exercise sovereign powers in the occupied Palestinian territory, and that its presence there is unlawful, such that it must be terminated as rapidly as possible. I refer as well to the Court's determination that Israel has an obligation to facilitate and not to impede the right of the Palestinian people to self-determination, including the right to a sovereign and independent state in the occupied Palestinian territory, and that Israel, by its presence in this territory, its annexations and its settlements, among other actions, has been systematically violating that obligation. The Court further determined that third states and the United Nations are legally obligated not to accept the Israeli presence in the OPT as lawful or to contribute to its maintenance, and must work to bring it to an end, and that they have an erga omnes obligation to support the right of the Palestinian people to self-determination. These determinations by the Court have at least three inevitable consequences for the present proceedings. First, because its presence in the OPT is unlawful and it lacks sovereign rights or powers within the territory, Israel has no legal authority to impede humanitarian goods and services from entering or circulating within the Gaza Strip or any other part of Palestinian territory. The decision to accept and receive humanitarian assistance, and from whom, is an exercise of sovereignty, which, in the case of the Palestinian territory, belongs exclusively to the Palestinian people, who are represented by the State of Palestine. Accordingly, in addition to its obligations to ensure and facilitate the provision of humanitarian assistance to the Palestinian civilian population under international humanitarian law, Israel bears an obligation under general international law not to override the sovereign will of the Palestinian people, expressed through their legitimate governmental representative, to receive in their own territory such urgently needed assistance and services as they may authorize from the United Nations, third states, and other trusted organizations. Second, Israel's prevention of humanitarian assistance from entering Gaza also violates its obligation, in the Court's words, quote, not to impede the Palestinian people from exercising its right of self-determination. As the Court explained, the right of self-determination includes the right to territorial integrity, the right to be protected against acts aimed at dispersing the population and undermining its integrity as a people, and the right of the people freely to determine its political status and to pursue its economic, social, and cultural development, all of which the Court found were violated by Israel's prolonged occupation of Palestinian territory. By preventing humanitarian assistance from entering Palestinian territory, Israel further violates each of these components of the right of self-determination. In particular, Israel's denial of food, water, and other essentials of life to the Palestinian civilian population inevitably impedes their economic, social, and cultural development. And it is intended, as Israeli officials themselves proclaim, to displace and disperse the Palestinian population, especially in Gaza, but increasingly in the West Bank as well, which undermines their integrity as a people. Mr. President, I see that the clock is approaching 11:30. I have somewhere between 5 and 8 more minutes of my speech remaining. If you allow me to continue, I would be happy to do so. If you prefer to take the coffee break, obviously that's fine with us. We're entirely in your hands.
I think we can have coffee after you finish your remarks.
Thank you very much, Mr. President. Israel's prevention of humanitarian assistance also violates the territorial integrity of Palestine, another essential component of self-determination. As shown on this map, in the southwest Gaza borders Egypt. The main border crossing is at Rafah, which is where most humanitarian assistance, before it was blocked by Israel, entered Gaza. Israel enforces its blockade on goods entering here from within Palestinian territory, thus violating its territorial integrity. The situation is similar in the east, where Israeli forces stationed in the West Bank, including East Jerusalem, prevent or restrict the entry of humanitarian assistance from Jordan via the King Hussein al-Karama bridge crossing, again, in violation of Palestinian territorial integrity. As the Secretary General observed, the humanitarian situation in the West Bank, including East Jerusalem, is also grave due to Israel's prevention or restriction of humanitarian assistance to the millions of Palestinians who live there. While Israel has not announced a formal cutoff of humanitarian assistance to the West Bank, as it has to Gaza, it has imposed major obstacles to the delivery of such assistance, including the arbitrary withdrawal or denial of operating permits for humanitarian organizations. According to the Commissioner General of UNRWA, while a number of international NGOs have already been silenced, there is now a larger concerted effort in Israel to undermine or restrict, through legislative measures, the operations of international organizations and NGOs. In occupied East Jerusalem, the agency is facing increased pressure from the municipality to vacate premises and end service provision. International staff have been effectively expelled from the occupied West Bank due to the lack of valid visas. The vast majority of the states and international organizations participating in these proceedings agree that Israel's shutdown of relief operations and denial of urgently needed humanitarian assistance to the Palestinian civilian population violate its duty not to impede the Palestinian people from exercising their right of self-determination. According to the Netherlands, for example, in a situation of extreme dependence on relief operations, the occupying power's unilateral decision to terminate its agreement and cooperation with a third party responsible for the bulk of the humanitarian assistance directly and severely affects a people as a whole, frustrating its economic, social, and cultural development. This has severe negative consequences on the ability of the people concerned to exercise its right of self-determination. The written statement of the Secretary General explains, quote, "The obligation of Israel to respect the right of self-determination of the Palestinian people has another important aspect: to respect the decision of the Palestinian people on the manner in which the dependence of the West Bank, including East Jerusalem and Gaza, on Israel for the provision of basic goods and services should be reduced. Therefore, in instances where the representative of the Palestinian people decided to receive basic goods and services from United Nations entities in order to fully enjoy its right of self-determination, Israel is bound to respect that decision." The third consequence of the 2024 advisory opinion is that Israel's prevention of humanitarian assistance from other states and the United Nations violates its duty not to prevent them from fulfilling what the court found to be their erga omnes obligations to support and facilitate the exercise of self-determination by the Palestinian people. Many states and international organizations emphasize this point. The African Union, for example, explains that as a member state of the international community, Israel must cooperate with third states to ensure the effective enjoyment by the Palestinian people of their right to self-determination. It must therefore grant all facilities at its disposal for the provisions by third states of the support necessary for the latter to be able to self-determine. Mr. President, I come now to the final part of my presentation, and the briefest, on Israel's legal obligations under parallel rules of international humanitarian law and international criminal law, particularly those which prohibit starvation of the civilian population as a method of warfare. This practice, which Israel, by admission of its senior government officials, deliberately employs against the Palestinian civilian population in Gaza, is unlawful under both Article 54.1 of Additional Protocol 1, which expressly prohibits it, and the Rome Statute, which provides in Article 8.2b that, quote, intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies, is a war crime. In fact, starvation of civilians as a method of warfare has been recognized as a war crime, at least since the judgment of the Nuremberg Tribunal in 1946. 8 decades later, it is Israel that is deliberately starving more than 2 million Palestinian civilians in Gaza to achieve its purported war ends by cutting off all supplies of food, water, and other essentials of life. This has led the International Criminal Court to charge Prime Minister Netanyahu and former Defense Minister Gallant with the war crime of starvation. In allowing the prosecution to proceed, the pretrial chamber of the ICC explained, there are reasonable grounds to believe that both individuals intentionally and knowingly deprived the civilian population in Gaza of objects indispensable to their survival, including food, water, and medicine and medical supplies, as well as fuel and electricity, from at least 8 October 2023 to 20 May 24. The distinguished legal advisor of Mexico, Pablo Arocha Olaguanaga, put it eloquently in an article he published last year. Its title is Starvation is Starvation is Starvation. People in Gaza are being starved to death, and we are all witnessing it, if not complicit in it. But this human tragedy is a deliberate choice. It is the consequence of a political decision. It is both avoidable and reversible. All of us, as diplomats, international lawyers, humanitarians, but most importantly as individuals, have the moral obligation to raise our voices in outcry of this catastrophe and in efforts to stop it. Israeli authorities must ensure complete and unfettered access for humanitarian goods throughout Gaza. Human dignity simply cannot be held hostage to conflict. This must stop. The inhumanity of this Israeli policy is compounded by its unlawful objective to forever extinguish the right of the Palestinian people to self-determination, including a sovereign and independent state in their own territory, as part of the two-state solution that the international community demands. Mr. President, killing and maiming hundreds of thousands and starving and attempting to displace millions of Palestinians out of Palestine amounts to no less than destroying them as a group. In conclusion, the State of Palestine respectfully submits that Israel's unconscionable violations of its legal obligations under international humanitarian law and under the rules of international law set out in the Court's 2024 advisory opinion must be called out by the Court in its forthcoming advisory opinion, and they must be stopped. International law, we contend, requires this. Maintaining the credibility of the rules-based international order demands it. Thank you, Mr. President and members of the Court, for your kind courtesy and patient attention, and I respectfully request that after the coffee break, you call my esteemed colleague, Blina Negrali, to the podium. Thank you very much, and thank you very much for permitting me the extra time to complete my speech.
I thank Mr. Leichler. Before I give the floor to the next speaker, the court will observe a coffee break of 50 minutes. The hearing is suspended.
wanna be saved.
Radio Swiss Jazz.
Baby, can't you see I'm calling? A guy like you should wear a warning. It's dangerous, I'm falling. There is no escape, I can't wait. I need a hit, baby, give me it. You're dangerous, I'm loving it. Too high, can't come down. Losing my head, spinning round and round. Do you feel me now? With a taste of your lips, I'm on a ride. You're toxic, I'm slipping under. With a taste of a poison paradise, I'm addicted to you. Don't you know that you're toxic? And I love what you do. Don't you know that you're toxic? Getting late to give you up. I took a sip from my telescope. Slowly, it's taking over me. Too high, can't come down. It's in the air and it's all around. Can you feel me now? I'm on a ride. You're toxic, I'm slipping under. With a taste of a poison paradise, I'm addicted to you, don't you know? With a taste of your lips, I'm on my
Tous les artistes suisses sont sur Radio Suisse Jazz.
sur terrain chéri, c'est ainsi que je veux passer mes nuits. Les deux dans le noir au creux du lit, nous pourrions dépenser nos nuits blotties. Nous deux corps soudain pris d'une folie, la suite tu te l'imagines aussi. Mes journées quand elles finissent, moi je plonge entre tes cuisses. Je ne connais pas pire vice, ni même de meilleurs supplices. Mes mains posent sur tes reins, chérie, c'est comme ça que nous nous passons nos nuits. Tout à coup tu te tords, tu me souris, et comme si tout de suite je t'ai compris. Jusqu'à ce que nous brûlions nos envies. Une chose est sûre, on est loin d'être endormis. Mes nuits illuminées par tes courbes endiablées, je ne saurais comment faire à tout simplement revenir en arrière. Sur terrain chéri, depuis que nous le faisons ainsi, je ne peux raconter tout ce que j'ai appris, de tes seins à tes reins jusqu'à tes chevilles. Les mots seuls ne leur font justice, tant pis, mais la lune, elle rouvit quand tu gémis. Nous n'avons aucun complexe durant nos breaks à parler de nos ex. Rien n'est honteux pendant le sexe, c'est reparti, fait péter les durex. Une main sur l'un de tes reins chéris, l'autre sur tes seins et viens ici. Des caresses sur tes fesses ça va aussi, mais mes mains sur tes reins ça me suffit. Pour cette nuit et qui sait pour toute la vie. Pour cette nuit et qui sait pour toute la vie.
when the land is dark and the moon is the only light we'll see. No, I won't be afraid. No, I won't be afraid. Just as long as you stand by me. So darling, darling, stand by me. Oh, stand by me. Oh, stand by me. Stand by me. Stand by me. If the sky we look upon, oh, should crumble and fall, or the mountains should tumble to the sea, what you gonna do? I won't cry, I won't cry, no, I won't shed a single tear, just as long as you stand by me. So darling, darling, stand by me. Oh, stand right by me. Oh, stand, yeah, stand by me, stand by me. Hey, hey. Mountains should fall, crumble into the sea. I won't cry, I won't cry. Oh, I won't shed a tear. No need, 'cause you, as long as you just stand by me. Stand by me. Whenever you're in trouble, just stand right beside me.
Swiss Jazz, la radio musicale della SSR.
There's a certain glow in the center of your eyes. It makes me feel like everything is alright, alright. I just can't control all these shooting stars inside. The feelings that collide when we're alone. Floating on the Milky Way, blazing like a star. The universe is ours to take. We can have it all if you just hold on to this heart and never let me go. To try's the only way we'll ever know. It's crazy when you look at me. Oh, I get these shooting stars every time that you hold me close. So darling, please, don't you ever let me go. There's a certain glow in the center of your eyes. It makes me feel like everything is alright, alright. I just can't control all these shooting stars inside. The feelings that collide when we're alone. Oh, we're floating on the Milky Way, blazing like a star. The universe is ours to take. We can have it all if you just hold on to this heart and never let me go. To try's the only way we'll ever know.
Radio Swiss Jazz.
We're forth. When I'm happy, I've got this groove when I walk. When I'm happy, my head goes back and forth. And I smile, 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 smile my way through. And I sing ooh, ooh, everywhere I go. Yes, I sing ooh, ooh, everywhere I go. And I sing ooh, baby, ooh, everywhere I go. And I smile, 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 smile my way through. And I smile when I wake up, ain't no time to be sad and blue. Smile when I wear my pants, tie my shoes and sip my coffee cup. And I smile when I wake up, ain't no time to be sad and blue. And I laugh, 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 babe, when you by my side. I sing ooh, ooh, everywhere I go. I sing ooh, ooh, everywhere I go. And I sing ooh, ooh, everywhere I go. Ooh, baby, everywhere I go. And I smile, 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 smile my way through.
Comes a rainstorm, put your rubbers on your feet. Comes a snowstorm, you can get a little heat. Comes love, and nothing can be done. Comes a fire, well, you know just what to do. Blow it higher, you can patch the inner tube. Comes love, and nothing can be done. Don't try hiding, 'cause it isn't any use. You start sliding when your heart turns on the juice. Comes a headache, you can lose it in a day. Comes a toothache, see your dentist right away. Comes love, nothing can be done. Comes a heat wave, you can hurry to the shore. Comes a summons, you can hide behind the door. Comes love, nothing can be done. Comes the measles, you can carry down a room. Comes a mouse, you can chase it with the broom. Comes love, and nothing can be done. Don't try hiding, 'cause there isn't any use. You will start sliding when your heart turns on the juice. Comes a headache, you can lose it in a day. Comes a toothache, see your dentist right away. Comes love, nothing can be, nothing can be, nothing can be, nothing can be done. To the shore, comes a summons, you can hide behind the door. Comes love, nothing can be done. Comes the measles, you can carry down the room. Comes a mousey, you can chase it with the broom. Comes love, nothing can be done. And you know what I'm just speaking of. Comes a nightmare, you can always stay awake. Comes depression, try to get another break. Comes love, nothing can be done. Nothing can be done. Nothing can be done. Nothing can be done. Nothing can be done.
State ascoltando Jazz Made in Switzerland, lo spazio dedicato alla musica svizzera.
Love me or leave me or let me be lonely. You won't believe me, but I love you only. I'd rather be unhappy than with somebody else. You might find the night time's the right time for kissing. Night time is my time for just reminiscing, regretting instead of forgetting with somebody else. Now I don't want that love unless that someone is you. I intend to be independently blue. Ooh, I want your love, don't want to borrow. Have it today to give back tomorrow. My love is your love, so give it to somebody else. Love me or leave me and let me be lonely. You won't believe me, but I love you only. I'd rather be unhappy than with somebody else. You might find the night time's the right time for kissing. Night time is my time for just reminiscing, regretting instead of forgetting with somebody else. Now I don't want no love unless that someone is you. I intend to be independently blue. Ooh, I want your love, don't want to borrow. Have it today to give back tomorrow. My love is your love, so give it to somebody else.
Radio Swiss Jazz, das Musikradio der SRG.
I've got the world on a string, I'm sitting on a rainbow, I've got the string around my finger. What a world, what a life, oh, I'm in love. I've got a song that I sing, I can make the rain go anytime I move my finger. Lucky me, can't you see, oh, I'm in love. Life is a beautiful thing, as long as I hold the string. I'd be a silly so and so if I should ever let it go. I've got the world on a string, I'm sitting on a rainbow, I've got a string around my finger. Whoa, lucky me, can't you see, I'm in love. Life is a beautiful thing, as long as I hold the string. I'd be a silly so and so if I should ever let it go. I've got the world on a string, I'm sitting on a rainbow, I've got a string around my finger. What a world, what a life. Hey, now I'm so in love.
Мы видим, что наша политическая, общественная, правовая система эффективно работают. В сложных условиях, в том числе внешнего давления, доказывают свою состоятельность и, особо подчеркну, подлинную суверенность. Главный залог такой прочности и надежности – самостоятельный выбор и доверие граждан нашей страны. Еще 2 столетия назад наш соотечественник, государственный деятель и реформатор Михаил Михайлович Спиранский отмечал, что государством 3 силы движут и управляют. Сила законодательная, исполнительная и судная, как тогда говорили. И добавлял, что начало и источник всех сил в народе, ибо они – ничто другое, суть как нравственные и физические силы людей. Важно, что сейчас, в наши дни, эти 3 силы, 3 ветви власти находятся в равновесии, действуют четко в согласии друг с другом. Потому что главным критерием при принятии всех решений, их движущим стимулом и стержнем служат именно национальные интересы. Не какие-то поучения со стороны, а твердая, суверенная воля народа России. Общее стремление обеспечить безопасность Родины и ее будущее. Хочу сказать, что весь парламентский корпус на всех уровнях достойно отвечает на вызовы времени. Парламентарии не раз уже говорил об этом, многое делают для победы, помогают фронтовикам, ветеранам боевых действий. Многие сами стали в ряды добровольцев, защитников Отечества. Безусловно, это сильный, мужественный поступок, вызывающий особое, искреннее уважение. Знаю то, что безусловным приоритетом для вас остается обеспечение задач специальной военной операции, поддержка оборонной промышленности, армии, флота. Спасибо за такое глубокое понимание своей гражданской профессиональной ответственности. Так, с участием всех парламентских фракций законодательно закреплен особый, абсолютно заслуженный высокий статус наших героев, участников специальной военной операции. Расширяются, донастраиваются меры социальной защиты их семей, родных, близких. Прошу вас и дальше постоянно вести эту работу совместно с правительством, Министерством обороны, другими ведомствами, Фондом «Защитники Отечества». Отдельно отмечу и вклад региональных команд, руководителей и законодательных собраний субъектов Федерации, в том числе деятельное участие в отправке гуманитарных грузов, в волонтерском движении, а также товарищескую помощь коллегам-законодателям в исторических регионах Донбасса и Новороссии. На пути их интеграции в единое социальное, культурное пространство России, в экономическое пространство. Практически в каждом регионе, в дополнение к федеральным, вводятся свои программы помощи участникам боевых действий и членам их семей. Уже говорил, что нужно внимательно проанализировать и обобщить такой опыт, используя лучшие практики, определить единые, базовые, если можно сказать, исходные стандарты поддержки для всех регионов страны. Знаю, что это непростая задача, регионы-то разные, естественно, но тем не менее стремиться к этому нужно. Полагаю, что координирующую роль здесь способен сыграть как раз Совет законодателей, а также парламентские ассоциации федеральных округов. Они тоже ведут большую содержательную работу, и в этой части ее можно и нужно активизировать. Тем более, что в органы представительной власти на всех уровнях уже приходят ветераны боевых действий. Надежные, ответственные, принципиальные люди. Они достойно заявляют о себе не словами, а конкретной работой, реальными делами, конкретными инициативами. Уверен, что таких парламентариев, депутатов будет все больше благодаря федеральной программе «Время героев». И, конечно, тем кадровым проектам, которые уже стартовали практически во всех регионах Российской Федерации. Уважаемые коллеги, естественно, что приоритет в вопросах безопасности, обороноспособности, противодействия внешним вызовам, рискам требует сегодня особого внимания. Заметно влияет на текущую структуру законодательного портфеля. Но как мы с вами не раз говорили, вызовы, с которыми мы сталкиваемся, не повод откладывать, а напротив, стимул более динамично решать задачи долгосрочного развития страны. И потому столь важно, что вы интенсивно работаете по всем значимым направлениям. Именно по всем. А это повышение качества жизни российских семей, вопросы демографии, укрепление экономики, нашей технологической независимости, поддержка деловой предпринимательской инициативы, развитие регионов, городов и поселков нашей большой страны, совершенствование институтов гражданского общества, вопросы, связанные со сбережением нашего культурного и исторического наследия. Так, например, только за минувший год принят закон о технологической политике с акцентом на развитие производства полного цикла на основе именно отечественных решений, а также законодательный пакет по модернизации фискальной системы, имея в виду прежде всего переход к более справедливому распределению налогового бремени. Особо отмечу, что созданы дополнительные правовые условия для привлечения инвестиций в восстановление, возрождение к новой жизни объектов памятников культурного наследия. Но и нерешенных, уважаемые коллеги, вопросов, конечно, много. Административных барьеров достаточно. Здесь все еще остается много работы. Прошу эту работу совместно с правительством, экспертным, деловым сообществом обязательно продолжать. Далее. Правовой фундамент передового, перспективного, растущего сектора экономики заложен законом о развитии креативных, творческих индустрий. Целые пакеты законодательных актов направлены на решение наиболее острых, актуальных проблем, волнующих граждан в части борьбы с кибермошенничеством и нелегальной миграцией. Вводятся новые меры поддержки семей с детьми, восстановленная индексация пенсий работающим пенсионерам. В целом, за 2024 год принято порядка 200 социально значимых законов. Для муниципального сообщества, конечно же, особое место занимает новый закон о местном самоуправлении, его роли в единой системе публичной власти. Здесь, мне кажется, мы сделали очень правильный шаг. Повторю, это лишь некоторые примеры по-настоящему крупных системных законодательных инициатив из разных отраслей права и регулирования. Также активно сенаторы Совета Федерации, депутаты Государственной Думы и региональных парламентов участвуют в разработке документов долгосрочного планирования, таких как «Стратегия пространственного развития России». Она утверждена правительством в декабре прошлого года, обозначает как общие сквозные приоритеты, так и особенности регионов страны. Наша задача – раскрыть потенциал всех субъектов федерации. Повторю, это вопрос гармоничного развития страны, вопрос справедливости и равных возможностей для граждан страны. Работа предстоит большая. У правительства, парламента, у регионов и местных органов власти много задач, в том числе по реализации обновленных национальных проектов. Каждый из них прошу взять на парламентский контроль, подключить все формы и механизмы обратной связи с людьми, чтобы объективно оценивать ход преобразований, видеть, насколько их результат соответствует ожиданиям общества и обязательствам государства. Много раз об этом говорил, да я уверен, каждый из сидящих в этом зале разделяет такой подход. Нам нужно отчитываться не количеством истраченных денег, освоенных ресурсов, а результатами конкретной работы. Смотреть на то, как жизнь людей меняется. Наконец, необходимое внимание следует, как и прежде, уделить и парламентской дипломатии. Разъяснять и твердо отстаивать нашу позицию, защищать правду, укреплять контакты по линии Евразес, ОДКБ, СНГ, БРИКС и ШОС со всеми нашими друзьями и единомышленниками, а их число растет, причем в разных странах и на разных континентах. Мы не отказываемся от контактов с западными парламентариями и в Северной Америке, и в Европе. Ну, не хотят, это их дело, но мы к этому всегда готовы, я знаю, всегда мы обсуждаем эти вопросы с руководителями обеих палат. Россия открыта для взаимовыгодного сотрудничества, поддерживает интеграционные процессы на принципах уважения к суверенитету друг друга, к нашей общей истории. Так уже завтра в Волгограде состоится международный форум «Великое наследие. Общее будущее». Он организован по инициативе парламентского собрания Союза России и Беларуси и приурочен к священной для наших братских народов дате – 80-летию Великой Победы в Великой Отечественной войне. Сердечно поздравляю вас с этим наступающим праздником. Мы гордимся подвигом наших отцов, дедов, прадедов и должны быть достойны этого подвига, видеть свой долг и так же, как они должны видеть свой долг в честном служении нашим людям, нашему Отечеству, народу России. Я хочу пожелать вам всего самого доброго и благодарю вас за внимание. Спасибо.
always late. Anytime we have a date, but I love him. Yes, I love him. I'm gonna walk up to his gate and see if I can get this thing straight, 'cause I want him. And I'm gonna have him say is you is or is you ain't my baby. The way you're acting lately makes me doubt you is still my baby, baby. Seems my flame in your heart is done gone out. A man is a creature that has always been strange. Just when you're sure of one, you find he's gone and made a change. Now is you is or is you ain't my baby.
Maybe baby's found somebody new. Now is my baby still my baby true? That has always been strange. Just when you're sure of one, you find he's gone and made a change. Now is you is, or is you ain't my baby. Maybe baby's found somebody new. Now is my baby still my baby true?
Radio Suisse Jazz.
changing to try and please me. You never let me down before. Don't imagine you're too familiar, and I don't see you anymore. I wouldn't leave you in times of trouble. We never could have come this far. Took the good times, I'll take the bad times, I'll take you just the way you are. I need to know that you will always be and the same old someone that I knew. I
a little thing worthwhile. When the moon comes up and the sun goes down, take a little time to smile. If you think you have a care, you can find it everywhere. They will vanish too, like the others do. Take a little time to smile. Smiles were meant to give away. Give 100 every day. If you know what good they do, why not try to give a few? Try it for a little while. If you want to live in style, when the moon comes up and the sun goes down, take a little time to smile. Smiles were meant to give away. At least 100 every day. If you know what good they do, why not try to give a few? Try it for a little while. If you want to live in style, when the moon comes up and the sun comes down, take a little time to smile. In the morning, in the evening, in the meantime, in between time, smile. Take a little time to smile. In a hurry, not to worry. In the meantime, in between time, smile. Take a little time to smile. Smiles were meant to give away. At least 100 every day. If you know what good they do, try to give a few. Try it for a little while. If you want to live in style, when the moon comes up and the sun comes
Please be seated.
Veuillez vous asseoir.
Good afternoon. The sitting is now open.
Bonjour.
The court meets this afternoon to hear Palestine complete its presentation, followed by the oral statements of Egypt and Malaysia. Palestine can use up to 1 hour of this afternoon's session. Egypt will have 45 minutes and Malaysia 30 minutes. The court will observe a short coffee break upon completion of Palestine's presentation. Je donne maintenant la parole au professeur Alain Pellet. Monsieur, vous avez la parole.
Monsieur le Président, Mesdames et Messieurs les juges, il m'appartient de tirer les conclusions des plaidoiries que vous avez entendues ce matin. Elles vont presque de soi. Le comportement inhumain et proprement monstrueux d'Israël vis-à-vis des Palestiniens habitant dans le territoire occupé ne laisse en effet aucune place pour le doute. Il consiste en une multitude de faits internationalement illicites qui entraînent à l'évidence et la responsabilité aggravée d'Israël lui-même et des conséquences pour les autres États et les organisations internationales. Selon une position isolée, que je cite, la question posée à la Cour porte uniquement sur les obligations d'Israël relatives à la présence et aux activités de certaines entités dans le territoire palestinien occupé. Fin de citation. Partant, il conviendrait, selon cet État, de ne pas se préoccuper des conséquences juridiques éventuelles qui découleraient, le cas échéant, de leur violation. C'est assez curieux. Il vous est demandé de déterminer quelles sont les obligations d'Israël en tant que puissance occupante et membre de l'Organisation des Nations Unies, en ce qui concerne la présence et les activités de l'organisation, d'autres organisations internationales et d'États tiers dans le territoire palestinien occupé en lien avec celui-ci. Sans qu'il soit besoin d'entrer dans le détail de la distinction entre normes primaires ou secondaires, art ou ago, peu importe, il est clair que la violation des premières, les normes primaires, est à l'origine de nouvelles obligations secondaires. Ces obligations sont indissociables les unes des autres et forment ce que la doctrine aujourd'hui dominante considère comme le système de la responsabilité internationale. Les unes comme les autres créent des obligations pour les sujets de droit. Il est totalement artificiel de les dissocier. Le libellé de la question posée à la Cour non seulement ne l'impose nullement, mais l'exclut. Les violations d'obligations primaires créent de nouvelles obligations secondaires. Établir une violation et ses suites constitue bien une opération unique. Mes collègues ont montré, après avoir défini le contenu des obligations imposées par les règles pertinentes du droit international, que nombre de ces obligations, et des plus essentielles, ont été violées par Israël, en lien avec l'objet de la question, compliqué mais précis, que je ne cite pas à nouveau, vous le connaissez. Détailler les suites de ces manquements en est le complément logique et nécessaire. D'ailleurs, à quoi pourrait bien servir d'énumérer les obligations d'Israël, dont la plupart non seulement sont bien établies, mais ont déjà été consacrées par la Cour, si vous n'en tirez pas de conséquences concrètes? Si l'Assemblée générale vous a demandé de vous prononcer à titre prioritaire et de toute urgence, c'est pour que vous alliez plus loin que ce simple rappel au vu de, je recite la résolution, la situation humanitaire désastreuse dans le territoire palestinien occupé. Et si, dans la même résolution, l'Assemblée exige d'Israël qu'il s'acquitte sans délai de toutes les obligations juridiques que lui impose le droit international, y compris celles qui sont énoncées par la Cour internationale de justice, il serait assurément très regrettable que vous en teniez une abstraite leçon de droit sans en tirer des conséquences concrètes. C'est, mesdames et messieurs les juges, de la survie de plusieurs millions d'êtres humains qu'il s'agit. De façon très imminente, plus de 2 millions de Gazaouis sont affectés depuis des mois par une insécurité alimentaire critique, déjà source de famine pure et simple pour nombre d'entre eux. Parmi bien d'autres sources dignes de foi, 8 rapporteurs spéciaux des Nations Unies avaient lancé un cri d'alarme à cet égard dès le 16 janvier 2024, c'est-à-dire 100 jours après le déclenchement des hostilités. La situation n'a fait qu'empirer depuis lors, et de façon très dramatique, jusqu'à la brève accalmie qui a suivi le cessez-le-feu adopté le 15 janvier 2025, même si, durant cette accalmie, des centaines de Gazaouis sont morts du fait des conditions de vie effroyables résultant du siège imposé par Israël pendant 15 mois, de l'insuffisance des aides qu'il a fugitivement autorisées, en dépit de ses engagements, et des offensives armées israéliennes jamais totalement interrompues. En outre, cette trêve partielle n'a pas bénéficié aux Palestiniens de Cisjordanie, notamment à Jénine, Naplouse ou Tulkarem, villes dans lesquelles ils ont été victimes d'incursions militaires par les forces d'occupation israéliennes, dans le cadre d'une opération intitulée Mur de fer, c'est un nom assez révélateur. Depuis le 18 mars 2025, les Gazaouis sont de nouveau soumis à un blocus implacable, aux bombardements israéliens accompagnés d'une large réoccupation partielle et à de nouveaux ordres de déplacement massifs. Comme l'ont affirmé les plus hauts responsables de l'OCHA, de l'UNICEF, de l'UNOPS, de l'UNRWA, du PAM et de l'OMS, le 7 avril dernier, je cite, « Plus de 2,1 millions de personnes sont à nouveau prises au piège, bombardées et meurent de faim, tandis que les vivres, les médicaments, le carburant et les abris s'accumulent au point de passage et des équipements vitaux sont bloqués. » Fin de citation. Paul Reichler l'a rappelé ce matin, le secrétaire général des Nations Unies s'est quant à lui indigné. No food, no fuel, no medicine, no commercial supplies, as aid has dried up, the floodgates of horror have reopened. End of quote. En s'opposant à l'arrivée de toute aide humanitaire à Gaza et en la limitant considérablement dans le reste du territoire palestinien occupé, Israël a violé un très grand nombre de normes impératives du droit international général, et quand les faits sont si graves, on en oublie les violations de règles, je dirais, simplement obligatoires. Je m'en tiendrai donc à celles enfreignant les obligations découlant de normes de jus cogens, étant rappelé que, conformément à l'article 41, paragraphe 3 du projet de la CDI, les conséquences particulières qui s'attachent à ces violations sont sans préjudice de celles résultant de tout autre manquement au droit international. D'abord donc, les conséquences de droit commun telles qu'elles sont énoncées dans la deuxième partie des articles de la CDI. Elles comportent la cessation du fait internationalement illicite, l'offre d'assurance et de garantie de non-répétition et l'obligation de réparer le préjudice causé par ce fait. Conformément aux principes codifiés à l'article 30 alinéa A du projet de 2001, Israël doit d'abord et avant tout mettre fin au bombardement, à ses incursions, au blocus qu'il a réimposé à Gaza et à celui qu'il continue d'imposer largement dans les villages et les camps de réfugiés de Cisjordanie. Cela signifie qu'Israël doit mettre un point réellement final aux entraves à l'entrée et à la délivrance de l'aide humanitaire dans le territoire palestinien occupé, y compris Jérusalem-Est, qu'il rouvre les points d'entrée par lesquels transite l'aide humanitaire à Gaza et bien sûr qu'il cesse de détruire les centres de distribution de l'aide humanitaire et qu'il retire ses forces d'occupation. Israël doit également renoncer à déplacer sans cesse les civils palestiniens, en particulier à Gaza, où près de 500 000, c'est le quart de la population de l'enclave, où près de 500 000 ont été obligés de fuir leurs habitats précaires entre la rupture du cessez-le-feu par Israël et la mi-avril. Depuis le mois d'octobre 2023, c'est 1 900 000 Palestiniens, soit environ 90% de la population gazaoui, qui ont été déplacés souvent de multiples fois. L'État hébreu doit aussi cesser de morceler le territoire palestinien de Gaza en multipliant les corridors qui isolent les Palestiniens les uns des autres et leur rendent encore plus difficile l'accès à l'aide humanitaire quand elle existe. Il a également l'obligation de ne pas renouveler les obstacles qu'il a mis à l'acheminement de l'aide durant la trêve, y compris les centaines de points de contrôle et de barrages routiers qui empêchent l'accès des Palestiniens à l'aide internationale. La CDI précise utilement dans son commentaire des articles de 2001 que, je cite, « la cessation n'est pas soumise aux limitations imposées par le critère de proportionnalité. » Israël ne saurait donc invoquer de prétendues violations qu'aurait commises l'État de Palestine ou d'autres entités pour s'affranchir de son obligation de se conformer immédiatement à l'ensemble des obligations lui incombant et qui violent les décisions et les actions et que violent les décisions et les actions continues que je viens d'évoquer. Autre précision importante qui est donnée dans l'article 29 du projet de la CDI, je cite, « Les conséquences juridiques d'un fait internationalement illicite n'affectent pas le maintien du devoir de l'État responsable d'exécuter l'obligation violée. Ce devoir est clairement lié à l'obligation de cesser le comportement illicite que consacre l'article 30A, la cessation étant en quelque sorte l'aspect négatif de l'exécution future. L'une et l'autre présentent une importance toute particulière dans la situation qui fait l'objet de la demande d'avis. Il en résulte en effet qu'Israël doit non seulement révoquer toutes les mesures d'interdiction ou de limitation d'acheminement de l'aide à la population palestinienne, qu'elle émane d'organisations internationales ou d'États, mais aussi qu'il doit s'acquitter positivement de ses obligations humanitaires de puissance occupante. Celles-ci sont énoncées dans les articles 56 et 59 de la Convention 4 de Genève. Elles incluent le devoir d'assurer et de maintenir, avec le concours des autorités nationales et locales, les établissements et les services médicaux et hospitaliers, ainsi que la santé et l'hygiène publique dans le territoire occupé. Fin de citation. Israël a en outre le devoir non pas seulement d'accepter les actions de secours d'autres organisations internationales ou d'États tiers, mais aussi de les faciliter dans toute la mesure de ses moyens. C'est d'ailleurs très exactement ce qu'exige l'Assemblée générale dans le deuxième paragraphe que j'ai cité il y a quelques instants de la résolution 79/232 qui est à l'origine de la demande d'avis. Il semble particulièrement important que votre avis précise expressément qu'Israël doit non seulement rapporter toutes les lois faisant obstacle aux opérations de l'UNRWA et des autres acteurs de l'aide humanitaire dans le territoire palestinien occupé, mais encore qu'il a le devoir de faciliter leur action irremplaçable et de garantir les immunités du personnel, des locaux et des biens des Nations Unies et des organisations internationales dispensant cette assistance. Dans l'affaire du mur, vous aviez déjà relevé que sa construction, je cite, entravait la liberté de circulation des habitants du territoire palestinien occupé, ainsi que l'exercice par les intéressés des droits au travail, à la santé, à l'éducation et à un niveau de vie suffisant. Plus généralement, comme vous l'avez observé dans votre avis de l'an dernier, que je cite, c'est l'ensemble du régime de restriction imposé à la liberté de circulation des Palestiniens dans le territoire palestinien occupé qui a un effet discriminatoire sur leur jouissance de ces droits. Dans cet esprit, Israël doit également, en application de la Convention sur le génocide, s'acquitter de son obligation de prendre sans délai des mesures effectives pour permettre la fourniture des services de base et de l'aide humanitaire requis de toute urgence afin de remédier aux difficiles conditions d'existence auxquelles sont soumis les Palestiniens de la bande de Gaza. Fin de citation. C'est ce que vous avez décidé dans votre ordonnance en indication de mesures conservatoires du 26 janvier 2024, dont il n'est pas inutile de rappeler qu'elle est juridiquement obligatoire. En outre, en application des mesures conservatoires supplémentaires, tout aussi obligatoires pour Israël, que vous avez décidé le 28 mars 2024, Israël doit, et je vous cite, la citation est un peu longue, mais elle est vraiment totalement adéquate pour notre affaire, l'État d'Israël doit prendre toutes les mesures nécessaires et effectives pour veiller sans délai, en étroite coopération avec l'Organisation des Nations Unies, à ce que soit assurée sans restriction et à grande échelle la fourniture par toutes les parties intéressées des services de base et de l'aide humanitaire requis de toute urgence, notamment la nourriture, l'eau, l'électricité, le combustible, les abris, les vêtements, les produits et installations d'hygiène et d'assainissement, ainsi que le matériel et les soins médicaux palestiniens de l'ensemble de la bande de Gaza, en particulier en accroissant la capacité et le nombre des points de passage terrestres et en maintenant ceux-ci ouverts aussi longtemps que nécessaire. Fin de cette longue citation. Plusieurs résolutions du Conseil de sécurité vont dans le même sens. Dans la plus récente de ces résolutions, la résolution 2735 du 10 juin 2024, le Conseil de sécurité demandait, je le cite, le retrait des forces israéliennes des zones peuplées de Gaza, retour des civils palestiniens dans leurs foyers et leurs quartiers dans tous les secteurs de Gaza, y compris dans le nord, et distribution sûre et effective d'une aide humanitaire en quantité suffisante dans toute la bande de Gaza à tous les civils palestiniens qui en ont besoin, y compris d'unités de logement fournies par la communauté internationale. Fin de citation. Et auparavant, dans sa résolution 2728 du 25 mars 2024, rappelant les résolutions 2712 et 2720 de 2003, le Conseil, je le cite, avait insisté sur la nécessité urgente d'étendre l'acheminement de l'aide humanitaire aux civils et de renforcer la protection des civils dans l'ensemble de la bande de Gaza et exiger à nouveau la levée de toutes les entraves à la fourniture d'une aide humanitaire à grande échelle, conformément au droit international humanitaire. L'Assemblée générale a adopté de très nombreuses résolutions allant dans le même sens. Comme les décisions et avis de la Cour, ces résolutions sont restées sans aucun effet. Jamais circonstances n'ont davantage exigé que l'auteur de faits internationalement illicites donne des assurances et garanties appropriées envisagée par l'alinéa B de l'article 30 des articles de la CDI. En espèce, il est tout à fait certain que de simples engagements qu'Israël viendrait à prendre, malheureusement de manière très hypothétique, d'assurer la mise en œuvre des mesures de réparation qui lui incombent, ces engagements ne suffiraient nullement à rassurer les victimes de ces agissements, qu'il s'agisse de la population palestinienne ou de l'État palestinien, non plus que de la communauté internationale qui a aussi un intérêt à leur cessation, tant il y a de raisons en l'espèce de penser que le simple retour à la situation préexistante ne protégerait pas la population palestinienne de manière satisfaisante. On peut en effet qu'être grandement préoccupé par la consistance avec laquelle Israël a fait fi des recommandations et des décisions des organes des Nations Unies, y compris du Conseil de sécurité, par l'évident mépris d'Israël pour les décisions de la Cour, par la légèreté avec laquelle il a, dans la violation la plus flagrante du principe de bonne foi, trahi ses promesses dans le passé, notamment en rompant unilatéralement, le 18 mars 2025, l'accord de cessez-le-feu conclu le 15 janvier précédent. Et il faut aussi garder à l'esprit qu'il est d'une importance proprement vitale qu'Israël cesse définitivement de violer continuellement ses obligations à la fois de puissance occupante, de membres des Nations Unies et tout simplement de membres de la communauté internationale des États dans son ensemble. L'État de Palestine a indiqué, à titre d'exemple, dans le paragraphe 7.23 de ses observations écrites, la forme que pourraient revêtir les garanties de non-répétition qu'Israël devrait prendre pour rendre crédible le respect de ses obligations dans le champ couvert par la demande d'avis. Nous sommes convaincus que des orientations précises en ce sens dans votre avis seraient particulièrement opportunes. Tournées vers l'avenir, les assurances et garanties visent à empêcher d'autres violations potentielles. Elles sont axées sur la prévention plutôt que sur la réparation. L'obligation de réparer constitue pour sa part la conséquence la plus fermement établie de tout fait internationalement illicite dès lors que celui-ci a causé un préjudice. Il ne s'agit évidemment pas pour vous, mesdames et messieurs de la Cour, de vous prononcer sur l'étendue des dommages résultant de la violation par Israël de ses obligations internationales, pas davantage que sur les modalités ou le montant précis de la réparation dont il doit s'acquitter en conséquence. Il ne peut faire de doute que les premiers, les dommages, sont immenses. La seconde, la réparation, doit l'être en proportion. Il n'est pas, je pense, utile que je m'attarde sur le justement fameux principe de Tchortchov, unanimement reconnu et repris dans l'article 31, paragraphe 1 des articles de la CDI, selon lequel l'État responsable est tenu de réparer intégralement le préjudice causé par le fait internationalement illicite. Il en résulte que la réparation doit autant que possible effacer toutes les conséquences de l'acte illicite et rétablir l'état qui aurait vraisemblablement existé si le dit acte n'avait pas été commis. Ces obligations s'imposent à Israël sous forme de restitution et à défaut d'indemnisation et de satisfaction dans la mesure où le préjudice ne peut pas être réparé par la restitution. Il n'est pas davantage besoin, Monsieur le Président, d'entrer dans le détail du droit applicable. Vous en avez subi le rappel à suffisance. En revanche, il ne me paraît pas inutile de m'arrêter brièvement sur les modalités particulières de réparation qu'appellent les circonstances de l'espèce. Bien qu'il ne s'agisse pas ici de réparer l'ensemble des conséquences résultant de l'occupation et de la présence illicite d'Israël dans le territoire palestinien, les constatations que vous avez faites l'an dernier dans l'avis sur les conséquences juridiques des politiques et pratiques d'Israël sont en grande partie transposables dans la présente affaire. Ainsi, il ne saurait faire de doute qu'Israël a, et je vous cite, l'obligation de réparer intégralement les dommages causés par ces faits internationalement illicites à toutes les personnes physiques ou morales concernées. Par les entraves illicites qu'il a imposées à la fourniture, et je vous cite à nouveau, d'articles de première nécessité, essentiels à la survie de la population civile palestinienne, ainsi que de services de base et d'une aide humanitaire et d'une aide au développement. Ceci est conforme à la règle codifiée à l'article 33 du projet de la CDI, selon lequel les obligations de l'État responsable peuvent être dues à un autre État, à plusieurs États ou à la communauté internationale dans son ensemble, en fonction notamment de la nature et du contenu de l'obligation internationale violée et des circonstances de la violation. En l'espèce, les manquements d'Israël à ses obligations humanitaires se sont traduits par de terribles souffrances humaines, largement irréparables par la restitution, à commencer par la mort de milliers de civils palestiniens, y compris des milliers d'enfants. La restitution, qui est la règle dès lors qu'elle n'est pas matériellement impossible, n'est pas exclue pour autant s'agissant d'autres dommages. Par exemple, en ce qui concerne la réparation des infrastructures publiques ou la reconstruction des infrastructures publiques, des accès aux points d'eau et du réseau d'électricité, la reconstruction des habitations, des hôpitaux et des écoles, ainsi que la restitution de matériel de soins ou d'enseignement par équivalence à ceux qui ont été détruits par les activités militaires israéliennes. Quant aux souffrances elles-mêmes, seule une indemnisation appropriée, combinée avec les excuses des autorités israéliennes, est de nature à en assurer la réparation. L'État de Palestine a lui aussi droit à réparation pour les nombreux dommages que la politique et les actions d'Israël, grossièrement contraires au droit international, lui ont fait subir et que mes collègues ont détaillé dans leurs interventions de ce matin. Il en va ainsi en particulier des préjudices collectifs subis par la population palestinienne, du fait notamment des déplacements incessants imposés par Israël à la population de Gaza et des expulsions auxquelles il a procédé en Cisjordanie, y compris Jérusalem-Est. Il en va de même de l'isolement des villages palestiniens rendus inaccessibles à l'aide humanitaire des États tiers ou des organisations internationales. C'est le cas également de l'atteinte en résultant portée au droit du peuple palestinien à disposer de lui-même. Ces dommages peuvent difficilement être réparés intégralement par la restitution ou par une indemnisation. Ici, des satisfactions appropriées sont dues et nous pensons qu'il serait fort utile que la Cour en donne des exemples. Il vous appartient aussi, mesdames et messieurs les juges, de préciser qu'Israël doit réparation aux Nations Unies, y compris à l'UNRWA, et aux très nombreuses autres organisations internationales et aux États impliqués dans l'aide humanitaire à Gaza et dans le reste du territoire palestinien occupé, pour les destructions causées à leur propriété, et il incombe aussi à Israël d'indemniser leur personnel ou leurs ayants droit victimes de ces exactions. Monsieur le Président, comme je l'ai dit en commençant, les violations des obligations incombant à Israël visées par la question qui vous est posée relèvent de ce que les articles 40 et 41 du projet de la CDI décrivent comme des violations graves par un État d'obligations découlant de normes impératives du droit international général. celles que la Commission avait considérées dans la première version de son projet comme des crimes internationaux de l'État. Je ne veux pas raviver cette querelle terminologique, mais il faut bien dire que l'expression avait le mérite de mettre l'accent sur la gravité des violations en cause. Dans sa rédaction actuelle, qui n'est d'ailleurs pas guère différente de celle retenue dans la première version du projet d'article, l'article 41 tire de ces violations des conséquences dirigées surtout vers les obligations corrélatives de l'ensemble des États de la communauté internationale et en particulier celle de coopérer pour mettre fin, par des moyens licites, à toute violation grave d'obligations découlant de normes impératives et celle de ne pas reconnaître comme licite une situation créée par une telle violation, ni de prêter aide ou assistance au maintien de cette situation. Dans ses observations écrites, l'État de Palestine a analysé en certains détails ses obligations incombant aux tiers, qu'il s'agisse d'États ou d'organisations internationales. Je me permets de vous y renvoyer. Il s'en déduit qu'Israël doit répondre de ses manquements à l'égard de la communauté internationale dans son ensemble et plus particulièrement des États et des organisations internationales dont il a empêché ou entravé et continue d'entraver l'action humanitaire dans l'ensemble du territoire palestinien occupé et tout spécialement à Gaza, contribuant ainsi à aggraver les souffrances du peuple palestinien privé de son droit fondamental à disposer de lui-même. En outre, le paragraphe 3 de l'article 41 précise que celui-ci est sans préjudice des autres conséquences prévues dans la présente partie, la partie 2 du projet d'article, consacrée au contenu de la responsabilité internationale de l'État et de toute conséquence supplémentaire que peut entraîner, d'après le droit international, une violation à laquelle s'applique le présent chapitre, celui qui est consacré aux violations graves. Dans les circonstances qui ont donné lieu à la présente demande d'avis, l'une de ces conséquences particulières tient à l'obligation d'Israël, comme de tous les autres États partis, de rechercher, en vertu de l'article 146 de la 4e Convention de Genève, je cite, « les personnes prévenues d'avoir commis ou d'avoir ordonné de commettre l'une ou l'autre des infractions graves définies à l'article suivant et de les déférer à ses propres tribunaux, quelle que soit leur nationalité, donc y compris s'ils ont la nationalité israélienne, ou de les remettre pour jugement à une autre partie contractante intéressée à la poursuite. » Parmi les infractions graves visées à l'article 147, on peut relever les traitements inhumains, le fait de causer intentionnellement de grandes souffrances ou de porter des atteintes graves à l'intégrité physique ou à la santé, la déportation ou le transfert illégaux, autant d'actes indiscutablement commis en exécution des décisions israéliennes visant, pour reprendre les termes de la résolution 79/232, à entraver la fourniture d'articles de première nécessité essentiels à la survie de la population palestinienne, ainsi que de services de base et d'une aide humanitaire et d'une aide au développement dans l'intérêt de la population civile palestinienne et à l'appui du droit du peuple palestinien à l'autodétermination. En outre, conformément à l'article 148, Israël ne peut s'exonérer lui-même ni exonérer une autre partie contractante des responsabilités encourues par lui ou par une autre partie contractante en raison de ces infractions. Les États doivent enquêter sur les crimes de guerre commis par leurs ressortissants ou par leurs forces armées ou sur leur territoire et, le cas échéant, poursuivre les suspects. Ils doivent aussi enquêter sur les autres crimes de guerre relevant de leurs compétences. Cette obligation figure également dans de nombreux instruments, notamment l'article 6 de la Convention sur le génocide de 1948, L'article 7 de la Convention de 1973 sur la protection des personnes jouissant d'une protection internationale ou l'article 7 de la Convention contre la torture et autres peines ou traitements cruels, inhumains ou dégradants de 1984. Ainsi que le précise le CICR, toutes ces obligations violées par Israël ont également un caractère coutumier. Dans son arrêt du 9 février 2022, la Cour a fait observer que, en vertu de l'article 146 de la 4e Convention de Genève, relative à la protection des populations civiles en temps de guerre, l'État concerné avait l'obligation d'enquêter, de poursuivre et de réprimer les personnes responsables de telles violations. La même obligation pèse sur Israël s'agissant de la poursuite, du jugement et de la punition des responsables des violations de ces obligations en vertu de ces mêmes dispositions. Monsieur le Président, je sais à quel point le rôle de la Cour est chargé, mais la célérité avec laquelle vous-même et vos collègues avez répondu à l'appel de l'Assemblée générale vous demandant de vous prononcer à titre prioritaire et de toute urgence montre que vous êtes conscient de l'enjeu. Vous devez alerter le monde avec l'autorité juridique qui est la vôtre et votre légitimité d'organe judiciaire principal des Nations Unies sur cette urgence absolue de mettre fin durablement à l'horreur que créent les actions d'Israël dans le territoire palestinien occupé et tout spécialement, mais pas seulement, à Gaza. Votre avis aura une valeur d'alerte d'autant plus irremplaçable que vous vous prononcerez en droit, de manière précise et détaillée, non seulement sur les conséquences des violations graves commises par Israël, mais aussi sur celles qui s'imposent à la communauté internationale dans son ensemble. Les manquements d'Israël ont directement porté atteinte au droit de nombre de ses obligations, au droit de nombre d'entre elles et d'entre eux, de ces organisations et de ces États, empêchés de fournir à la population palestinienne l'aide humanitaire indispensable. En outre, vous ne manquerez pas de rappeler que le caractère impératif des obligations violées leur impose également des devoirs. Mesdames et Messieurs de la Cour, tous les professeurs de droit international ont essuyé le feu nourri de questions dubitatives de leurs étudiants sur la nature réellement juridique du droit international. Et dans le contexte géopolitique actuel, l'interrogation pénètre l'opinion publique mondiale dans son ensemble. On ne peut pas demander au droit plus qu'il ne peut donner. Par essence, il est normatif et prescriptif. Mais c'est une vision erronée des choses que de soutenir pour autant qu'il ne sert à rien. Il sert, et c'est déjà beaucoup, à montrer le chemin, à dire, au-delà des vérités alternatives, quels sont les principes et les règles qui doivent guider l'action des États et des autres sujets de droit pour assurer la promotion de la paix et la justice dans le monde, où elles sont aujourd'hui si dramatiquement menacées. Pour cela, vous avez un rôle éminent à jouer. J'ai été interviewé récemment par un grand journal français, dans lequel j'ai dit que votre avis de juillet dernier avait sauvé l'honneur du droit international. Nous avons la conviction que le nouvel avis que vous rendrez à la demande urgente de l'Assemblée générale justifiera la même appréciation. Je vous remercie très vivement de votre attention et je vous prie, Monsieur le Président, de bien vouloir donner la parole à son Excellence, Monsieur Riyad Mansour, pour quelques propos conclusifs.
Je remercie, Professeur Palais. I now give the floor to His Excellency, Dr. Riyad Mansour. You have the floor, sir.
Excellence, je vous en prie.
Thank you.
Mr. President,
Monsieur le Président,
honorable judges,
Mesdames et Messieurs les juges,
it is an honor to address you,
c'est un honneur
and
pour moi
I
de
have a
m'adresser
burden
à
to
vous.
speak on behalf
Mais c'est aussi
of a
une
people
lourde
as it is
charge
being decimated.
de s'exprimer au nom d'un peuple
We
qui est en
are
train d'être
proud
décimé.
of being
Nous sommes fiers
Palestinians,
d'être palestiniens.
but being Palestinian
Mais
comes
être palestinien
with its share of pain,
s'accompagne de son lot de souffrances.
and it has never been more
Et
painful
il n'a
to
jamais
be
été aussi
Palestinian
douloureux
than today.
d'être palestinien qu'aujourd'hui.
Why does Israel destroy
Pourquoi
homes and
Israël
hospitals?
détruit-il maisons et
Why
hôpitaux?
does it destroy
Pourquoi
vital
détruit-il des
infrastructure and
infrastructures
humanitarian
vitales et des
projects?
projets humanitaires?
Why does Israel hinder
Pourquoi Israël
or block assistance to the
entrave-t-il
Palestinian
ou
people,
bloque-t-il l'aide
including
destinée au peuple
and
palestinien,
indispensable to the
y
survival
compris l'aide indispensable à la survie
of the
de la
population
population
or to meet their most
ou
basic
à la
needs?
satisfaction de ses besoins les plus élémentaires?
Why does it attack humanitarians,
Pourquoi attaque-t-il le
killing
personnel
those trying to
humanitaire,
save
tuant
lives?
ceux qui tentent de sauver des vies?
The answer is deeply linked
La réponse
to this
est
court's
étroitement liée à
2024
l'avis rendu
opinion
par cette Cour en 2024
to entrench its unlawful
pour
presence,
conforter sa présence
to deny
illicite,
us our right
pour
to
nous priver de
self-determination,
notre droit à
to
l'autodétermination,
dispossess,
pour
displace
déposséder,
and destroy
déplacer
our people,
et détruire notre
to
peuple,
colonize and annex
pour
our land.
coloniser et annexer notre terre.
Israel is openly confessing
Israël avoue
to these
ouvertement
goals.
ses objectifs.
The Israeli Prime Minister has
Le
openly
Premier ministre
instructed
israélien a
his
ouvertement donné
occupation
l'ordre
army
à son armée
to
d'occupation
seize Palestinian
de
land
s'emparer
in
des
Gaza.
terres palestiniennes à Gaza.
His government considers that
Son
all
gouvernement
of the West
considère
Bank is
que
theirs
toute la
to claim.
Cisjordanie lui appartient.
Israel has admitted to
Israël a reconnu
voluntarily blocking aid
bloquer
and to
intentionnellement
the use
l'aide
of aid
humanitaire
as a
et
weapon.
s'en servir comme d'une arme.
Israeli officials
Les responsables
have been
israéliens
clear that they
ont
consider
clairement
nobody
indiqué
in
qu'ils ne
Gaza
considéraient
to be innocent.
personne à Gaza comme innocent.
They are seeking to end
Ils
our
cherchent à mettre
presence
fin
in the
à
land
notre
as a nation.
présence sur cette terre en tant que
Netanyahu
nation.
has said
Netanyahou a
unambiguously
déclaré sans équivoque
that he will not allow
qu'il ne
the
permettrait
exercise
pas
by the
au
Palestinian
peuple
people of their
palestinien
right to
d'exercer son droit
self-determination,
à l'autodétermination,
including the right
y
to
compris
their
son
independent
droit
state.
à un État indépendant.
The Israeli Knesset
La
adopted
Knesset
laws to
israélienne a
entrench
adopté des
this
lois
denial
visant
of our
à
rights
consacrer ce déni
and
de
of
nos
our
droits et de
existence
notre
as a nation.
existence en tant que nation.
The Israeli courts shielded
Les tribunaux
those
israéliens
committing all
ont
these
protégé
crimes.
les auteurs de tous ces crimes.
It is thus no coincidence that
Il n'est donc
most
pas
of the
fortuit que la
humanitarian
plupart
and
des projets
development
humanitaires et
projects
projets de
destroyed by
développement
Israel
détruits
in the
par
West Bank
Israël en
over
Cisjordanie
decades
au cours
were the ones
des dernières
intended
décennies étaient
for
destinés
communities in East
précisément aux
Jerusalem
communautés
and
de
in the so-called Area
Jérusalem
C,
Est et de la
the
zone
areas
dite
that
zone
constitute
C,
priority targets
des régions
of
qui constituent les
Israelis'
cibles prioritaires des
annexation
mesures
efforts.
d'annexion prises par Israël.
By denying these communities a
En
place to
privant
live,
ces communautés d'un
to
lieu
study,
où vivre,
to heal,
étudier,
by
et
denying
se soigner,
these their
en leur
access
refusant
to electricity
l'accès
and water,
à l'eau et à
as many of my
l'électricité,
colleagues have stated
comme
in
de
their statements, by denying them
nombre de mes collègues l'ont
international
déjà dit dans
protection
leurs
from
exposés,
violence,
en leur
Israel
refusant la
pursues
protection internationale
their
contre la violence, Israël
erosion.
cherche à les effacer.
It is no coincidence
Il
that
n'est pas
Israel
fortuit
destroyed
qu'Israël ait détruit à
in
Gaza
Gaza all the requirements
tout ce
for
qui
our
était
people's
nécessaire
lives
à la vie
and for their very survival,
et à la survie
including
même de notre
hospitals
peuple,
and
notamment
schools,
les hôpitaux et les
shelters
écoles,
and
les abris
bakeries,
et les boulangeries,
farmlands
les
and
terres
water
agricoles
and
et les
sanitation
installations
facilities.
d'approvisionnement en eau
It is
et
no
d'assainissement.
coincidence that
Il n'est pas
Israel
fortuit qu'Israël
bombs
bombarde
and kills
et
the
tue
humanitarians
le
who are
personnel
trying to
humanitaire qui
assist
tente
an
d'aider
entire civilian population to
toute une
survive,
population civile à survivre
killing,
en
maiming,
tuant, mutilant,
detaining, and
détenant
torturing
et
UN
torturant
personnel,
des membres du
humanitarian
personnel des
and
Nations Unies,
doctors,
des travailleurs
attacking the
humanitaires et des
convoys
médecins,
of
en attaquant
international
les convois de
volunteers
bénévoles
and killing
internationaux et en
Palestine
tuant
Red Crescent,
des membres
civil
des équipes
defense
du Croissant
and
Rouge
rescue
palestinien, de la
teams.
défense civile et
It
des
is
secours.
to deprive the population of any assistance
Consiste à
so
priver
it
la
had
population
no
de
means
toute
to
aide et
survive
partant de
the
tout moyen
devastation,
de survivre
death,
à la
and destruction
dévastation,
imposed
à la mort et à
on
la
it by
destruction
Israelis'
que lui
relentless
infligent les bombardements
bombardments,
incessants
its
d'Israël,
leveling of
la
homes
destruction
and roads and
de ses maisons,
infrastructure,
de ses routes
and
et
its
de ses
inhumane
infrastructures,
siege.
ainsi que son siège inhumain.
Now, after having killed
Aujourd'hui,
and maimed hundreds of
après avoir tué et
thousands of
mutilé des centaines
Palestinians,
de milliers de
Netanyahu
Palestiniens,
calls for
Netanyahou appelle
the
à la
voluntary
migration
migration
volontaire
of the
des
survivors.
survivants.
Is it voluntary migration
Peut-on
when
parler
to
de migration
destroy
volontaire
a
lorsque l'on
people
détruit
you
un
leave
peuple
them trapped
pris
between
en
death
étau
and
entre la
displacement?
mort et le déplacement?
Is it? We want life
Peut-on vraiment
and liberty and
parler
dignity
de
in our
migration
land
volontaire dans de telles
and in our
circonstances?
children's
Nous
lifetime.
voulons la vie, la liberté et la
Instead,
dignité sur
our
notre terre
children
et
are
du
being
vivant de
killed,
nos enfants.
orphaned,
Au lieu de cela,
amputated,
nos enfants sont tués,
traumatized,
privés de leurs parents,
displaced,
amputés,
humiliated,
traumatisés, déplacés,
witnessing and
humiliés,
enduring
témoins et victimes
what no
de
child
ce qu'aucun
should
enfant
witness
ne
or
devrait
endure.
voir ou subir.
Those who survive
Ceux qui
will
survivent
never fully recover
ne se remettront
from
jamais
this
complètement
nightmare.
de ce cauchemar.
At the heart of the UN Charter, there is a
Au
pledge,
cœur de la Charte des Nations
the
Unies
ultimate
figure un
goal
engagement,
behind the creation of this
l'objectif ultime qui
organization,
a sous-tendu la création de
to
cette
save
organisation,
successive
prémunir
generations
les
from
générations
the
futures
scourge of
contre
war.
le fléau de la guerre.
Well, successive Palestinian generations were
Plusieurs
left to
générations
endure
successives
wars
de
and
Palestiniens ont été
occupation.
condamnées à endurer les guerres
And this
et
Palestinian
l'occupation.
generation
Et
is
cette
being killed,
génération-ci
and
est en
its
train de se faire
genocide
tuer.
is live
Et son
streamed
génocide est
for
retransmis
all to
en
see.
direct au vu de tous
And it continues with no end
et
in
sans
sight.
issue visible.
Pope Francis, may he
Le
rest in
pape
peace,
François, paix à son âme,
rightfully said,
a dit à juste
I
titre,
quote,
je cite,
"This is not war,
ce n'est pas une
this
guerre,
is cruelty."
c'est de la cruauté.
End of
Fin de
quotation.
citation.
What makes this even more
Ce qui rend la
outrageous
situation plus
is the
scandaleuse
fact people fleeing
c'est le fait que les
bombardments and
personnes qui fuient les
displaced
bombardements
time and time
et
again,
subissent de
coping
multiples
with terrible
déplacements
loss,
confrontés à des pertes
are
terribles,
denied aid that
se voient
is
refuser
almost
une
within
aide
grasp.
qui se trouve quasiment
They
à
are
portée
starving
de sa main.
while food rots
Elles meurent de faim
at the
tandis que la
border.
nourriture pourrit à la frontière.
They are dying of wounds
Elles meurent de blessures
that could be
qui
healed.
pourraient être soignées.
They are succumbing
Elles succombent
to
à
disease
des
that
maladies
could be
qui
prevented.
pourraient être
The
évitées.
UN Office of High
Le
Commission
commissariat
for
des
Human Rights
Nations Unies
stated
aux
a
droits de
few
l'homme a
days
déclaré
ago,
il y a quelques jours,
and I quote,
et je cite,
extremely high civilian casualties over
le nombre
18
extrêmement
months
élevé de victimes
do
civiles
not
recensées
appear
au
to
cours
have
des 18 derniers
prompted
mois ne semblent
any
pas avoir
changes
conduit
in
à un
Israeli
changement
targeting
dans les
practices and
pratiques
policies.
et les politiques
A
israéliennes en
pattern
matière de
indicating at
ciblage,
the very
ce qui
least
témoigne à tout le
a
moins
complete
d'un
disregard for the
mépris
lives
total
of civilians
pour
in
la vie
Gaza.
des civils à Gaza.
Match with Israelis policy
Conjugué à la politique
of deliberately
israélienne
blocking
consistant à
life-saving
empêcher délibérément
assistance from
l'acheminement
entering the Gaza
de l'aide
Strip, these
humanitaire vers
policies
la bande de
appear
Gaza,
to be
ces
aimed
mesures
at
semblent
punishing
viser
the civilian population of
à punir
Gaza
la population
and
civile de Gaza
inflicting on them
et à
conditions
lui
of
infliger des
life
conditions de vie de
increasingly
plus en plus
impossible with their
incompatibles
continued
avec
existence
son
as a
existence
group
en tant
in
que
Gaza.
groupe
End of
à Gaza.
quotation.
Fin de citation.
Why did humanity enact rules
Pourquoi
if those who
l'humanité
are
a-t-elle adopté des
entitled
règles
to
si
their
ceux qui
protection
peuvent bénéficier de la
are left
protection
in
qu'elle
harm's
confère
way
sont laissés pour
and
compte
those who should
et que
be
ceux
held
qui devraient
responsible
être
for their
tenus
breach
responsables de
are
leurs
shielded?
violations sont protégés?
Among the rules considered the most
Parmi les
sacred
règles
in the
considérées comme
international
les plus sacrées
order are
dans l'ordre
the
international
prohibition of
figure
aggression
l'interdiction de
and its
l'agression
corollary is the inadmissibility of
et
the acquisition
partant
of territory by force,
l'inadmissibilité de l'acquisition
the
de
prohibition
territoire par
of
la force,
genocide,
l'interdiction du génocide,
the prohibition of crimes against
l'interdiction des
humanity,
crimes contre l'humanité,
the prohibition of racial discrimination and
l'interdiction de la
apartheid,
discrimination raciale
the
et de
prohibition
l'apartheid,
of torture,
l'interdiction de la torture
as well as respect for
et le respect
the basic rules of
des règles
international humanitarian
fondamentales
law
du droit
and the
international
right of
humanitaire et du
self-determination.
droit à l'autodétermination.
There can be no justification
Rien
for
ne
such
saurait justifier
indiscriminate,
une violation
widespread,
aussi
and
aveugle,
systematic
généralisé
breach of
et
these fundamental
systématique de
rules
ces règles fondamentales
that lie at the heart
qui sont
of the
au cœur
international
de
law-based
l'ordre
order.
fondé sur le droit international.
No justification whatsoever
Rien
for
ne saurait
abandoning
justifier
an entire
d'abandonner
nation
une nation
to
tout
the
entière
most horrific fate.
au sort le plus effroyable.
Denying humanitarian and
La
development
privation
assistance
d'aide
to the
humanitaire
Palestinian
et d'aide
people
au développement
is an
au
integral
détriment du
part
peuple palestinien
of the
fait
breach by
partie
Israel
intégrante de la
of the
violation
rights of
commise
the
par
Palestinian
Israël des droits
people
du peuple
guaranteed
palestinien
by these
garantis
fundamental norms.
par ces normes fondamentales.
It is paramount that the court,
Il est
while
primordial que la
determining
Cour,
Israel's
tout en
obligations
déterminant les obligations
in
d'Israël
relation to these
au
norms,
regard de ces normes,
also remind all
rappelle
states,
également à tous les États,
I repeat, remind all
je
states
répète, à tous les États
and the international
et
community
à la
as a whole
communauté internationale dans
of
son
their
ensemble
obligation
leur
to bring
obligation
those
de
breaches
mettre
to an end.
fin à ces violations.
Ensuring accountability
Veillez à ce
to
qu'Israël
end
rende
these
des comptes pour
breaches
mettre
is
fin
the
à ces
assistance
violations
we
et
most
l'aide dont
desperately
nous
need.
avons le plus désespérément
We need your
besoin.
help.
Nous avons besoin de
What
votre
is
aide.
the path towards upholding our
C'est
right
la
to
voie à suivre pour faire respecter
self-determination,
notre droit
to
à
development,
l'autodétermination,
and even to
au
life?
développement et même à la vie.
That would allow all other
Cela
assistance to reach
permettrait à toute
us,
autre aide de nous
or
parvenir,
better
ou
still,
mieux encore,
ensure that we will
de
no
garantir
longer be
que nous
in need
puissions
of such
nous passer
assistance.
d'une telle aide à l'avenir.
Which begs the question,
Ce qui pose la question
why does the
suivante.
Palestinian
Pourquoi
people need
le peuple
assistance to
palestinien
begin with?
a-t-il besoin d'aide?
We do not lack the
Nous ne manquons
resources, and we
de
certainly do
ressources
not lack
et nous ne
the human
manquons
capital.
certainement pas
As
de
long as
capital
our
humain,
people stop
à
being
condition
killed
que notre
and
peuple
displaced.
cesse d'être tué et déplacé.
Israel annexes
Israël
our land.
annexe nos terres.
It kills,
Il tue,
dispossesses, and
dépossède et
displaces
déplace
to destroy our
pour
people.
détruire notre peuple.
It steals our
Il
resources
vole
and
nos
revenues.
ressources et nos sources de
It
revenus.
fragments our
Il
territory.
fragmente notre territoire.
It severely
Il
restricts
restreint
our movement and access.
gravement nos déplacements et notre accès aux
From the
ressources.
18-year blockade
Du blocus
over Gaza
imposé à Gaza
to the
depuis
nearly
18 ans,
1,000
auprès
military
de 1000
checkpoints
postes
and
de contrôle
obstacles
militaire et obstacles
to access
à l'accès
to access and movement
et
in the
à
West
la
Bank,
circulation
to the
en
attempts
Cisjordanie,
to sever
en passant
East Jerusalem
par les
from its
tentatives visant à
Palestinian
couper
environment.
Jérusalem-Est de son
Israel
environnement
systematically
palestinien.
created our
Israël a
dependency
systématiquement
on aid
orchestré notre dépendance
and
à
then
l'aide
deliberately
avant
deprived
de nous
us
priver
of this
de
aid.
cette aide de manière délibérée.
Kill and
Tuer
displace,
et déplacer,
destroy to replace.
détruire pour remplacer.
Get rid of
Se
Palestinian
débarrasser de
demography
la
to
démographie
seize
palestinienne
Palestinian
pour s'emparer
geography.
de la géographie
The
palestinienne.
methods are illegal
Les méthodes sont
and inhumane.
illégales et inhumaines.
The real objectives
Les objectifs
pursued are
véritablement
unlawful,
poursuivis sont
and the
illicites
means
et les
deployed are
moyens
criminal.
déployés sont criminels.
I like to repeat that.
J'aimerais le
The
répéter.
methods are
Les
illegal and
méthodes sont
inhumane.
illégales et inhumaines.
The real
Les
objectives
objectifs
pursued
véritablement
are
poursuivis
unlawful,
sont illicites
and the means
et les
deployed
moyens
are
déployés
criminal.
sont criminels.
A UN member state
Un État membre de
openly
l'Organisation
shredding
des
the
Nations
UN
Unies qui
Charter
déchire ouvertement la Charte des
in
Nations
the
Unies
General Assembly, attacking the
devant l'Assemblée
UN,
générale, attaque
killing UN personnel,
l'Organisation des Nations Unies, tue des
bombing
membres du
facilities
personnel de cette
and
organisation,
inciting
en bombarde
against
les
the
installations
organization.
et incite à la haine à son encontre.
That member state,
Cet État membre,
its foreign minister today, wants
dont
you to put to
le ministre
trial
des Affaires
the Secretary
étrangères
General of the UN
veulent
and the Commissioner
que,
General of the UN,
vous
Mr.
souhaitiez,
Lazzarini. You see how he is standing on his head
dans le cadre d'une
instead
procédure,
of-
M. Lazzarini
instead
ainsi
of
que le
standing on
secrétaire
his
général des Nations
feet.
Unies.
A member state breaching
Un État
resolutions
membre qui viole
of the Security
les
Council
résolutions du Conseil de
and the General
sécurité,
Assembly
de l'Assemblée
and the Human
générale
Rights
et
Council
du Conseil des
and
droits de l'homme
smearing them
et les
for
10 femmes
adopting
pour
these
avoir adopté
resolutions
ces
grounded
résolutions
in
fondées
international law.
sur le droit international.
A member state,
Un État membre
a UN member state, attacking the
de
principal
l'Organisation des
judicial
Nations Unies qui
organ
attaque l'organe
of the
judiciaire
UN
principal
and
de
marking
cette
the most
organisation et se moque
elementary
des
and
règles les plus
fundamental
élémentaires
rules
et
of our
fondamentales de
international
notre ordre
law-based order.
international fondé sur le droit.
A UN member
Un
state
État membre
openly
de l'Organisation des Nations
aiming to
Unies qui s'emploie
destroy an
ouvertement à
entire UN
détruire
agency,
un organisme
UNRWA,
de l'ONU. Dans sa
protesting
totalité,
its
l'UNRWA,
continued
en
existence
déplorant qu'elle existe,
while it is Israel's
qu'il existe
expulsion of
encore,
Palestinians
alors
and
que c'est l'expulsion
denial
des
of the
Palestiniens
right
par Israël
of
et le déni
return
du droit au
of
retour des
Palestinian
réfugiés
refugees
palestiniens
that has led
qui ont conduit
to the
à la
creation of
création
this
de cet
agency
organisme
and required its
et
continued
rendu nécessaire
existence for
son
over
existence
7
pendant
decades.
plus de 7 décennies.
UNRWA is the shining
L'UNRWA
example
est
of
un
the success of
exemple flagrant
multilateralism at the
du succès
UN.
du multilatéralisme
It is a remarkable
au sein
organization.
du système des Nations Unies.
This
C'est une
is what we
organisation
should be
remarquable.
proud of
C'est
as an
ce dont
organization
nous devons
in a
être
selfless
fiers au
way,
sein de cette organisation.
catering to the
Une
needs
organisation
of
qui sans
6
relâche
million
subvient aux besoins de 6
Palestinian
millions
Palestine
de
refugees
réfugiés palestiniens
and giving almost 300
et qui
individuals
donne
in the process of providing humanitarian assistance
une
to the
assistance
Palestinian
humanitaire
people
aux
in
Palestiniens
Gaza.
par l'entremise
It
de
is
près de
something
300
that all of
personnes.
us at the UN should be
Nous
so
devrions
proud of that
tous
it has
être
been in
si
business
fiers
for almost 75 years.
de l'existence de
It is
cette
an
organisation
organization
depuis
that
près
should
de
be
75 ans. C'est une
defended,
organisation qui
not to be
devrait être
attacked.
protégée, défendue et non pas attaquée.
A UN member state
Un État
openly
membre
destroying
de
an
l'ONU
entire
qui détruit
people.
ouvertement un peuple tout entier.
Till when can this
Jusqu'à quand
situation
cette
be
situation
tolerated?
sera-t-elle tolérée?
Till no Palestinian survives?
Jusqu'à ce qu'il ne reste
Till
plus
no
un seul
Palestinian
Palestinien?
child is spared?
Jusqu'à ce qu'aucun enfant palestinien ne soit épargné?
There is an alternative vision.
Une autre vision est possible.
One where the law is
Celle
upheld,
dans laquelle le droit est respecté,
where no
où
civilian
aucun
is
civil
harmed,
ne souffre,
whether Palestinian or
palestinien
Israeli,
ou israélien,
where there are no
où
prisoners
il n'y a plus
and no
ni
hostages,
prisonniers ni otages,
no occupation
ni occupation,
and no wars,
ni guerre,
where families are
où les
reunited
familles
in
sont
life
réunies dans la vie
rather than death,
plutôt que dans la mort,
where our people are
où nos
finally
peuples
free
sont enfin libres
and where two
et où
states
deux États
live side by side
coexistent
in peace
dans la paix
and
et
security,
la sécurité.
where all
Où
recognize
tous
our
reconnaissent
shared humanity
notre humanité commune
and that all peoples are
et que tous les peuples
endowed with
sont
rights
dotés de droits
and that every life
et que
is
chaque
sacred.
vie est sacrée.
Every life of everyone from
Que la
all
vie
peoples
de
in the region
chacun,
and beyond
de
is
tous les
sacred.
membres, de tous les peuples de la région est sacrée
Not the life of some
et pas la vie de
and to
certains.
deny the sacredness
Et
of
non
the
pas
life of others.
d'autres.
We are equal.
Nous sommes égaux.
We should be equal.
Nous devrions
We
être
are all
égaux.
the children of God,
Nous sommes tous des enfants
and
de
God
Dieu.
does not
Et
discriminate
Dieu ne fait
among
aucune
his children
distinction
or
entre ses
against his
enfants.
children. Where you do not need to ask what is the
Où il n'est plus
nationality
nécessaire de
or
demander la
religion or
nationalité,
race
la religion
of a child
ou la
killed
race d'un enfant
to
tué
know if you should
savoir
be outraged
s'il faut
or
être
find
indigné ou
excuses.
trouver des excuses.
Where parents
Où les
do
parents
not live in
ne
fear.
vivent pas dans la peur,
Where children
où les enfants
do not discover
ne découvrent pas la
death
mort
before they had a chance
avant
to
d'avoir eu
experience
la
life.
possibilité de connaître la vie.
That alternative vision
C'est cette autre vision
is why humanity
qui
enacted
a poussé
rules
l'humanité à adopter
and
des règles
established courts
et à créer des instances
to bend
judiciaires
the arc of the
pour
moral
infléchir l'arc
universe
de l'univers
toward
moral
justice.
vers la justice.
To bend the arc
Pour
of the
infléchir
moral
l'arc de
universe
l'univers
toward
moral
justice.
vers la justice.
Justice, not
La
vengeance.
justice et non la vengeance.
Justice,
La
not double
justice et non un
standards.
système fondé sur
Justice,
deux poids,
not
deux mesures.
cruelty.
La justice et non la cruauté.
We are here because the General
Nous sommes ici
Assembly
parce que
needs
l'Assemblée
your
générale
guidance
a besoin de vos
to
lumières
advance
pour
justice.
faire progresser la justice.
We are here as
Nous
millions
sommes
of
ici en tant que
Palestinians,
millions de Palestiniens.
in particular,
Et
2
en
million plus
particulier,
in Gaza.
les 2 millions, les
Half
plus de
of
2
them
millions
children
à Gaza, pour moitié des enfants,
pay the ultimate
qui
price
payent le prix
for
ultime
our
de
collective
notre
inability
impossibilité
to end,
collective à
to
mettre
end
fin
the
à
injustice.
l'injustice.
Help us
Aidez-nous
deliver
à
justice.
obtenir justice.
Help us to move in that direction
Aidez-nous à
and to
avancer
have
dans
justice
cette
for the
direction
Palestinian
et à
people.
obtenir justice
I
pour le
thank you
peuple
very much,
palestinien.
Mr. President.
Je vous remercie, Monsieur le Président.
I thank the
Je
representatives
remercie
of
les
Palestine
représentants
for
de la
their
Palestine pour leur
presentation.
présentation.
Before I invite the next
Avant d'inviter la
delegation to
délégation
take the
suivante à
floor,
prendre la parole,
the court will
la
observe
Cour
a
observera
coffee break
une
of
pause
50
de
minutes.
15 minutes.
The hearing is
L'audience est
suspended.
suspendue.
Radio Swiss Jazz.
I'm confessing that I love you. Tell me, do you love me too? I'm confessing that I need you. Honest, I do. Need you every moment. In your eyes I read such strange things, but your lips deny they're true. Will your answer really change things, making me blue? I'm afraid someday you'll leave me, saying can't we still be friends? If you go, you know you'll grieve me. All in life on you depends. Am I guessing that you love me? Dreaming dreams of you in vain. I'm confessing that I love you over again. Depends. Am I guessing that you love me? Dreaming dreams of